Supreme Court in civil, to 489.
Number urgency con.
Because Honorable Appeals Court has directed to deposit. Instead of depositing, they have filed an execution.
Phase second appeal, my lord, stay of execution.
My lord, phase second appeal, my.
Yes, sir, appointment matter.
I
also have given some memos, my lord.
Yeah, Mr. Ponda, don't think, but each and every memo is being examined. Don't think that I'm just simply saying that. Yeah, it will just adjust kori.
Lordship chathro mention kor sarleni kintu
Koron tale. Aw koron tuni. Na aw koron tuni. Chathro kor sarleni jodi heini apno kora koron tuni. Hoboni da mane. Chathro ja alani pass boli kichi mane.
Lordship press matter to lordship. My lord, item number 28. Item number 28. Last occasion there is a connected matter with the 1028, my lord. On the last occasion, lordship.
My lord, sorry, my lord. In that item number 28, on the last occasion, I had mentioned that it is linked with WPC number 35187 of 2020. Because there was an earlier order of this honorable court, my lord, that it has already been detached. So your lordship wanted that both the cases to be taken up on the same day, even though those are not tagged. But today, my lord, only one case has been listed.
What is the other case?
My lord, WPC number 35187 of 2020.
Oh. The other matter does not is not of my assignment. That is why it has been detached.
Achha.
How it is
Sir,
if
necessary,
I adjourn it. Don't worry.
My submission, my lord. Today, for some reason or other, my lord, the officer is not also provided with that file.
Yeah, it's all right.
So for that reason, my lord, this
let it reach and adjourn it. Make a mention or adjourn it. Yes.
Most of them.
Your lordship, item 30 on behalf of SK Nanda.
30.
Again.
Yes.
SK Nanda is the accommodation. So let the matter in Nanda.
This matter next week is good.
Supplement list item number 1 for judgment.
In the result, the appeal succeeds and is therefore allowed. The impugned judgment passed by the first appellate court is hereby set aside. The judgment and decree passed by the trial court is hereby confirmed. Parties to bear their own cost.
Item number 2 for judgment.
The hills and is therefore dismissed but without any costs.
Item number 3 for judgment.
For the foregoing reasons, therefore, the writ applications are allowed. The opposite party authorities are directed to issue orders of engagement in favor of the petitioners for the post of Shiksha Sahayak / junior teacher schematic, as the case may be, against the unfilled vacancies without any further delay, and in any case not later than 2 months from the date of production of certified copy of this order by the petitioners.
Okay. Item number 4 for judgment.
In the result, this court finds no merit in the appeal, which is therefore dismissed, but in the circumstances without any cost.
Item number 5, press admission.
My lord, the petitioner is the wife of the opposite party. She has filed an application for transfer of the petition for divorce filed by the husband in the court of the Learned Judge Family Court Kendrapada to the Learned Judge Family Court Jharsuguda.
You want it to be transferred to Jharsuguda?
Jharsuguda, my lord. On the ground that prior to...
All right, take notice. Yes. To the opposite party by speed post, fixing a short returnable date, requisites be filed by tomorrow. Place this matter on 9th October. Stay cordial.
Item number 6.
Mr. Naik. Yes, Mr. Naik. Sir. No, Mr. Naik. Kindly leave that seat, please. There is an arguing counsel's chair. Yes.
Please listen. So the petitioner is the legal married wife of the opposite party to transfer the MAT case number 45 by 23 from senior division 8 to civil judge senior division banking.
On what ground?
Sir, petitioner is the only distressed lady and her father भी अच्छे 55 किलोमीटर होचंदी sir banki ru ଆଉ 8
All right, take notice. Notice, stay. 9th October, na? 9th October. Yes.
Oblige.
Item number 7,
Pass over.
item number 8,
Pass over.
item 9,
Pass over.
item number 10,
This petitioner was working as a Anganwadi worker. Your lordship would find at annexure 1, age 10, my lord. She has been engaged since 2011. 2011 ରୁ କାମ କରି ଆସୁଥିଲା. Then my lord, for some reason the center was going on in her in-laws house because no individual building or room was there for the center to run because my lord, the center was running in her in-laws house. There was a dispute in her in-laws house and they drove her out. That is the compelling circumstances. She had to leave that village and go to her parents. For that reason, she was absent for about 4 months. Then, my lord, a letter was issued. The next letter, annexure 3, my lord, the CDPO concerned has asked her to hand over the charges, page 12. Annexure 3. The charges was handed over to the nearby center, my lord, the Anganwadi worker of the nearby center. Then, my lord, the next page 13, your lordship would find annexure 4.
Yes.
There was a show cause notice issued by the sub-collector Sonpur.
By appropriate disciplinary action shall not. So she submitted a reply.
My lord.
Then
Next page is the reply, my lord. And I have written that there was a severe dispute in my in-laws' house. They have beaten me. They have drove me out of the house. Because of that reason, I was not able to discharge my duties. I had to go to my parents' house. All these things have been stated in the show cause reply. Then, my lord, all of a sudden, they have issued this notification,
you have
advertisement.
not been disengaged. There has been no order of disengagement.
No letters after this show cause reply, no letter has been communicated to me. No personal hearing has been accorded to me, my lord. No disengagement. All of a sudden, they have issued this advertisement to fill up that concerned post, my lord.
Take notice.
I would request my lord friend to give me a copy of a legible.
All right, I'll pass that order. Sri R. Das, learned AG, accepts notice on behalf of all the opposite parties. 2 legible copies of the writ application along with annexures be served upon him within 3 working days. Let a counter affidavit be filed, specifically indicating as to what was taken against the petitioner pursuant to the show cause notice issued on 4/9/2023. So, IA. It is submitted that despite issuance of the show cause notice and submission of reply thereto by the petitioner, no action has been taken against her so far. Stop. As such, she is continuing to discharge her duties as Anganwadi worker.
Miller, charges were handed over as per their order. Charges were handed over.
As Anganwadi worker, though.
Now not allowing me to continue.
Though, though she has handed over charges of the center to the Anganwadi worker of the nearest center.
Nearby,
Nearby center.
Yes, nearby Anganwadi center.
In the meantime, an advertisement has been issued on 10/7/2024 for engagement, for fresh engagement of Anganwadi worker. Since prima facie there is no specific order disengaging the petitioner from the post held by her, I am inclined to pass an interim order to the effect that operation of no selection shall be made pursuant to the advertisement dated 10/7/2024 bracket annexure 6 till the next date.
Your lordship may say with respect to this center, how would the center be actually set
In respect of insofar as the same relates to
page 16
the
Khorjura Harijana Pada.
In respect of only insofar as only in respect of Khorajura Harijana Pada Anganwadi Center. Yes. Let's just matter on 23rd October.
My lord, beg pardon, item number 9, my lord.
Wait. Which has been passed over, it has gone.
23rd September. 23rd September.
Item number 11,
Item 11. Matter relating to publication of selection list pursuant to the advertisement made in the year 2010 relating to Kasturba Gandhi Balika Vidyalaya selection. I have no instruction,
Dispose of, no instructions disposed of.
but my power was not there.
Anyway, no instruction disposed of.
Giving a meeting.
item number 12,
Report of DEO.
Yes. I should have got a additional copy of what he has said. But if your lordship permits, I can hand over.
This is what I wanted.
Yes, your lordship wanted. to
The report
look
of
to
the
that-
DO.
Yes. Of 28 May 2011.
By the way, what is this matter? Why did I want this?
Because that was the basis on which the action was taken.
You are Jayanta Kumar Samal,
No, I am Sridhar Behra.
Sridhar Behra,
Both.
watchman. Acha. As per the records mentioned in this case, Jayanta Samal and Sridhar Behra have been appointed as counsel. They say that you have resigned.
No, but in fact, there is no such document that I had resigned. But that was the case created by the headmaster while appointing two other persons. When I was continuing and when the school came to granting it for, they appointed two persons, that is the sons of two of the member of the managing committee. And shown me that we have resigned from the post. But my lord, prior to that, an inquiry was conducted. On the last occasion, I had taken your lordship to that page 28, 29 and 30. A detailed inquiry was conducted.
Page?
Page 29, that is answer 10. The inquiry report. My lord, the inspector of school directed the headmaster to submit the proposal in favor of the petitioner. He did not submit. Thereafter, another letter was issued directing the headmaster to submit the proposal in favor of the petitioner, since he submitted the proposal in favor of two other persons, saying that after my resignation, those two persons have been appointed. And I have also filed an application to implement that person as a party. That petition is pending.
Will allow it.
Unless that person who has been appointed against me,
All right.
he will be affected. That
IA 19018 of 2023. This is an application to implead one Tapan Kumar Naik as opposite party number 6. It is submitted that if the prayer of the petitioner is favorably considered, then said Tapan Kumar Naik would be adversely affected.
Yes.
And therefore he is a necessary party. Stop. Then State Council has no objection to the prayer for addition being allowed. In such view of the matter, the IA is allowed. Learned counsel for the petitioner is permitted to Tapan Kumar Naik to include the persons shown in the schedule as opposite party number 6. Consolidated cost title be filed within 3 working days.
Yes.
Further, requisites be filed for issuance of notice on the said on the newly added opposite party by registered post with AD,
within 3 days, I will file.
returnable within 4 weeks. Requisites for which shall be filed within 3 working days. Let's this matter
23rd October.
on 23rd October.
Kindly Give me for a moment. Your Lordship may see the prayer of the writ petitioner, Your Lordship. It relates to his approval of service. Since the matter relates to approval, this is not maintainable before this honorable court. Your Lordship.
We'll see that. That is always open to you to argue. I have not passed any order on merits. he wants to add a party.
That argument was on behalf of one of my learned friend, my lord, and your lordship had also gone through that section 10A, and after that, the order was.
That is solid.
Yes, yes.
It is still open to you to make that argument. Doesn't matter.
Item number 13.
My lord,
That's all.
in that case, my lord, filing the note of submission to the my lord.
In 13.
No, no, not in this. On 22nd, it was had passed forward.
Item number 14.
Pass over, Mila. 14 pass over.
Oh, sabu pass over aji. Item 15.
Item number 15.
Here, my lord, the petitioner was selected as Anganwadi worker. Your lordship may kindly see the advertisement. On run
Yes.
page 60, your lordship has heard the matter and directed the state to take instruction over the matter whether the ADM has jurisdiction actually to quash the advertisement.
Yes. That matter. Yes.
Whenever your lordship's number one is without giving opportunity of hearing. Number two is he has no jurisdiction because he is the approving authority for the advertisement. ADM is the approving authority for the preparation of the advertisement. He can't, my lord.
No, my view, prima facie, it may not be my final view, was that an advertisement can be withdrawn, can be cancelled in the administrative side. But as an appellate authority, I don't think he has the power to quash the advertisement. Can he?
He cannot.
Language, my lord, that has.
Yes, please.
Yes, that is there, my lord, in the order.
Yeah, what do you say? What do you say?
No, that is the condition what it has been imposed by the appellate authority, my lord. Now it is before your lordship.
I don't think
CDPO has issued advertisement. So see the appellate IDM is the
appellate authority can only decide the correctness of the decision taken by the selection authority, either in disengaging or appointing somebody whose appointment is under challenge. But to cancel the advertisement, I don't think he has the power.
He cannot be the appellate authority of his own cause because he is the approving authority of the advertisement. ADM is the approving authority of the advertisement.
I'll go
and
through.
you also may kindly see for a moment page 17.
Page 17.
17 of my brief.
Yes.
Sure, my lord, for 5 Anganwadi centers advertisement was published. 5 Anganwadi centers. I am one of them. Another is another writ application in respect to another person.
Chapter writ applications.
2 writ applications. Initially 2 writ applications. Subsequently, whenever advertisement was cancelled, this writ application. Earlier, my lord, we are selected. Appointment was given. Whenever we went to join, my lord, we are not allowed. We filed writ application before this honorable court. This honorable directed to consider the representation.
In the meantime, I had challenged that. Though that was first, thereafter I came before this.
Let him complete. Let him complete.
Consideration, my lord, that was directed by this honorable court. Whenever consideration, they have rejected, posing a point that whether we are eligible. The state has clarified the counter. My lord, admittedly, it is a scheduled tribe area. And the petitioner, each of the both petitioners, they belong to nearby areas. Whenever if scheduled tribe candidates is not available, they can give appointment. They have stated in the counter. You lordship may kindly see the counter filed by the state. The 2 guidelines they have given. Para 15 and para 16, B by 5 and C by 5. D by 5. C by 5 and D by 5 of the counter.
Yes.
That is clarified. We are eligible. We have been selected. Appointment was given. And whenever we went there, we are not allowed. On the plea that villagers are opposing. Nothing more.
Because advertisement was invited only from ST candidates.
Kindly see page 15 of the. I may be permitted to read this.
Page 15 of?
Of the counter submitted state.
You have to mention the running page.
My lord, running page, I am sorry for that, your lordship.
All right.
C by 5 of C by 5 and D by 5.
Counter filed by opposite party 1 to 6.
Counter filed by opposite party note 2 to 5.
There is no counter. You are referring to some other writ application, probably.
8807.
8807. Double eight. I'm sorry.
That is the sub item.
Sub item.
In that case, I have filed one IA for intervention.
C by 5. Yes.
With reference to the subject noted above, I am directed to clarify that if eligible candidate from this area are not available, candidates from village area may be taken. If from village area not available, then from adjacent village within GP areas may be considered for selection of Anganwadi workers. And subsequent also the same. In partial modification, you will also kindly see page 60, D by 5. It is issued to all collectors. In partial modification of the revised guidelines issued by letter number such and such for selection of Anganwadi workers, the following amendment is made in para 1 of the aforesaid guideline. In case no man is found eligible from those residing in the service area, then women from other parts of the same village will be considered. If no man is found eligible from the village, then women from the same Gram Panchayat will be considered. The OP number 7 belongs to scheduled caste candidates. But we are scheduled tribe, and that is that the Anganwadi center is meant for scheduled tribe. Whenever this writ applications is kept pending, challenging that rejection order of the collector, what has happened? He filed an appeal before the
ADM.
First of all, she is not a candidate. She is not an applicant. Whether not being the applicant, suppose application is submitted being a scheduled caste candidate, and rejected, then she has a right to challenge. Even if she says that though there is no provision for scheduled caste persons, therefore the advertisement is valid. She has never applied, or at the very inception she has not challenged. Selection was completed, appointment was given, writ application was filed, direction was given for consideration. Thereafter she filed one application, appeal before the ADM. Not making all the parties. You will also again come to page 17 of my brief. 5 Anganwadi centers area are there. 5 persons have been given appointment. 3 persons are continuing now on being appointed, have joined. Only 2 persons are restrained. And thereafter he filed for only one Anganwadi center.
Where is that order?
Order. Order dated 49, page 49 orders. Annexure 11.
Annexure 11 of which writ application again?
25094 of 2000.
Yes.
What is that illegal mail in that order?
Upon substitution.
All right.
My lord.
So that is your case.
My lord, that is my case.
I'll briefly ask the state and then I will hear you. Yes.
My lord. My lord, one advertisement was issued specifying that, my lord, this post is meant for ST category.
Yes.
Now, my lord, once there is a provision, my lord, this post is exclusively meant for ST category. In case of non-availability of the ST category candidates, there is also possibility on SC category candidates. But for that reason, presuming that no post will be made available, my lord, the advertisement was issued. To that extent, my lord, that only, sorry, my lord, without presuming that one, the only condition was imposed, my lord, ST candidates are there, they are available. But once it is the view of the appellate authority that it is not the selection process, my lord, which was actually under challenge. The very condition laid down in that advertisement, stipulating and restricting it to the ST category candidate and without making it open for the SC category candidate even for application. That was the subject matter of consideration before the appellate authority. Since he went to that particular subject matter, my lord, and decided that non-consideration of the SC category candidates and non-reflecting the eligibility of the SC category candidate to apply in terms of this particular advertisement is wrong. That is why, my lord, he had to interfere with the advertisement itself.
Now, whether he has that power, that has to be seen, because as per the guidelines, the ADM will be the appellate authority for hearing complaints.
Yes.
Regarding selection of Anganwadi workers for tribal and rural projects and urban projects.
Yes, ma'am.
Right. So complaints regarding selection.
Now, my lord, somebody has to
Now-
take that particular pen, my lord, with respect to that.
Obviously,
advertisement. That is wrong.
obviously. But here, what does it mean? Somebody who is not an applicant,
Yes,
who is not a candidate, can he or she an appeal?
my lord, that is the point, my lord, what it
No, PIL is PIL and writ application.
কিন্তু স্যার এথিরে মানে at a time of taking into consideration this particular appeal, my lord, the appellate authority, as it is evident from the appellate order, my lord, that this petitioner, the person, my lord, whose appeal has been taken into consideration, he has been deprived of applying the
See, what he could have done, he could have approached the collector
Yes.
by or the ADM by submitting a representation. That could have been considered in the administrative side. A decision could have been taken. But when you assume an authority, I am posing this question to you whether it is open to you. Number one. Number two, you being not a candidate. Second, the appeal is confined only to deal with the complaints relating to selection or otherwise of the Anganwadi workers. This is not a question of selection. But whether the selection process is wrong, somebody ought to have been selected, has not been selected, and those things of that kind. Third is, this advertisement covers 5 Anganwadi centers.
Yes, ma'am.
So whether it is open to him to cancel it or yes. Well,
I
yes,
think we
please.
have not
My
been
humble
made
submission,
parties.
Lordship.
Yes, yes.
We have not been parties, neither myself nor any
Yes, yes.
candidate selected.
My
for
humble
that.
submission, when in all other Anganwadi, both SC and ST candidates were invited, for in particular in those 5 centers, that CDPO issued advertisement only allowing ST candidates.
No, you heard my question. You have to answer my question. You heard my question posed to the state council.
My lord, I prefer,
You were not an applicant.
no. When SC candidates were not allowed, how can I apply? For that, I challenged advertisement before this honorable court in WPC, challenging that advertisement because I had no other option. This thereafter, this honorable court that I have annexed that order in my IA. Last occasion also
In which writ application?
in WPC, Lordship in IA 8807 what IA କରିଛି. One IA number 15463.
Yes, yes.
ସେଇଥିରେ page number 6. Last time also Lordship has seen that.
So what was the order?
In this
Liberty-
case, when I challenged that advertisement for passing this honorable, what hell, my lord, para 4.
There was a wrong submission made by the state council.
Mr. D.K. Mahanti, London Additional Standing Counsel for the state, raised preliminary question with regard to the maintainability of the reproduction and submitted that against the selection and engagement of government worker, appeal lies, and instead of preferring appeal, the petitioner has
Even otherwise, even forget about that submission. Paragraph 5. Come to paragraph 5, sir. Please come to paragraph 5.
In view of the above, this court is not inclined to enter this application. However, liberty is granted to petition to approach the appropriate.
Yes, to approach the appropriate forum. This court never said that you file an appeal. They just recorded the submission of the state council that an appeal lies.
Prefer appeal লেখা আছে। Instead of preferring appeal lies to the instead of preferring appeal, petitioner approach the court. Appeal lies କରୁଛି ଲେଖିଛନ୍ତି ବା para 4 ରେ।
Sir, paragraph 4 is the submission of the state council.
My lord.
He has reproduced the submission of the state council.
My lord.
This court. Now, what is the final order of the court is in paragraph 5. Plain and simple. This court is not inclined to entertain this application. Liberty is granted to the petitioner to approach the appropriate forum. So you could have submitted a representation to the collector or ADM or whoever is the appropriate authority. You could have passed an order. Anyway, so that is your point. Then
when SC candidates were not allowed, for that I was agreed. Thereafter, I preferred appeal before the ADM. ADM accepted, and though in a single advertisement, 5 government centers advertisement were issued, for that ADM held last. Public association is not in due procedure, though that advertisement were issued when all both SC and SC candidates were allowed, for in particular 5, when no ST candidates are there in our village, 77 families are there, not a single ST candidate are there, and who has been selected, she belongs to other village, not in particular our Anganwadi center area. For that we challenge. Though no procedures as per guidelines issued by the government in women and childhood development for selection of it. The procedure has not been followed. For that, this advertisement is quest is the case.
My lord, in addition to that, may I take a lordship to one more?
My clear was both should be allowed. যেহেতু অন্য আরেক করুছ এটি কাই ছাড়? Yes.
My lord, there is another document, my lord, annexure 9, page number 30.
Which
The
again,
first-
which
the
writ
first writ petition.
which writ
In the first writ petition, my lord, that is
Annexure 9?
25094. Yes, ma'am.
Annexure 9, yeah.
Page 30 was most vital. Collector has rejected his application after selection. Se ଲେଖୁଛନ୍ତି collector କଣ କହିଛନ୍ତି? That is not
So
vital.
before that, my lord, this petitioner had previously approached before this honorable court. And that is in WPC number 31889 of 2021. And on the basis of this direction of this, your lordship, the representation submitted by the petitioner that was considered and that was disposed of by the collector. And this rejection, this order obtained to 2022 with respect to the
30.
petitioner, that is actually the subject matter in the second one. That is
Yes.
8807 of 2022, where he has prayed to pass this. She has prayed to pass this. Right. So not only the appellate authority, my lord, the collector has also taken decision in that particular action, my lord, that is on 10/2/2022.
Page 30, most vital.
Wherein, my lord, there is already a decision, and whereas having regard to the order number 1 dated 26/10/2021 passed by the Honorable High Court in WPC number 31889 of 2020 and by resolve of all relevant documents available in the record, it is crystal clear that withhold of the appointment of the CDPO Khajuripada in favor of the petitioner Subhasmita Kaur has rightly been issued, and the same will stand till receipt of the clarification from the government in WCT department as required by the DSW of Kandhamal. Accordingly, the petition at Annexure 7 and the paper will be disposed of. So, in fact, that was the subject matter of challenge in the previous case, my lord. In the meantime, an appeal has been filed. But another important thing, my lord, in our counter, my lord, in our counter we have stated that is the counter claim.
I can prove it. 8807.
ମାନେ ଟୋଟାଲି ଫୁଲବାଣୀରେ ବୋଥ ଏସି ଆଉ ଏସଟି କ୍ୟାଣ୍ଡିଡେଟ୍ ଆଲାଉ କରାଯାଇଛି ପର୍ଟିକୁଲାର ଇନ୍ 5 ଅଙ୍ଗନବାଡି ସେକ୍ଟରରେ ଓନ୍ଲି ଏସଟି କ୍ୟାଣ୍ଡିଡେଟ୍ କୁହାଯାଇଛି ମାଇ ପ୍ରେୟାର ୱାଜ ଓନ୍ଲି ବୋଥ ସୁଡ୍ ବି ଆଲାଉ ଆଉ କିଛି ନାହିଁ नो एसटी कैंडिडेट्स इन दैट लोकालिटी
नहीं sir, they are during the appeal, my lord, we had taken a stand that since he had not preferred an appeal, we had not allowed to hear the petitioner in that case. In our counter also, my lord, we are saying that.
All right, I'm closing it.
Yes, ma'am.
My lordship,
My lord, yes.
come to
Sorry,
this
my lord.
submission
Actually,
advance by my lord.
my lord, lordship may peruse the counter submitted by opposite part now 126 dated 22/9/2023. Their lordship may come to para number 5, man.
Yes.
That in reply to the amendment made in paragraph number 1 of the writ petition is humbly submitted petition on file the writ petition under Article 20, challenging the order dated 17/6/2022 passed by the ADM Kandhamal, Fulbani in MC number 1 of 2021 by holding that the advertisement number 359/36/2021 published by the CDPO Khajuripada is not in due procedure as per the guideline issued by Sansu due to continuous complaint of the opposite party. Full stop. Present petitioner Subhasmita Kaur never appealed to the ADM in this matter, so it was not necessary for giving notice to the present petitioner or opportunity of hearing. At the time of disposal of the appeal matter, which is impugned, this is also the
My lordship, consider that annexure 9. Admittedly, my lord, we have been selected, your lordship, and collector has said we have been rightly selected. There is no illegality whenever selection is concerned. What came to the mind of the collector, your lordship may kindly see the para 4 of page 30. The collector wants to know the eligibility. He sought for clarification regarding eligibility. Your lordship may kindly see. Whereas perused the PWC of CDPO Khajuripada, the CDPO stated in our PWC that as per government Women and Child Development Department guidelines issued by letter note such and such and letter note such and such. The advertisement for selection of Anganwadi worker in Pondarabadi Anganwadi Center under Odosipoda Grama Panchayat of Khojuripoda block from among the ST candidates belongs to Anganwadi Center service area. But in the instance case, Sri Subhasmita Kaur, who was selected as Anganwadi worker, is not coming under the Anganwadi Center area. After receipt of the complaint from villagers of Pondarabadi around such and such, the appointment order has been withheld until further orders by the order dated such and such. Whereas the government in Women and Child Development Department guidelines issued by letter note such and such speaks that in all the TSP area, any ST candidates will be eligible who belongs to the service area of the Anganwadi Center. In case no suitable ST candidate is available in the Anganwadi Center area, then it may be made open to SC candidates. But the revised guidelines such and such that in case no woman is found eligible from the service area of concerned Anganwadi Center, then women from other village as well as the GP will be considered. In this context, the DSW Kandhamal has speaks clarification from the government, but then the state has come forward by filing that guidelines. I had shown to CY 500. If it is not available, then from the same village and the nearby village and from the Gram Panchayat. So there is nothing wrong in selection. And collector has said in the last paragraph that my friend has read.
They have never read. When in total full.
Hearing concluded, judgment reserved. That is my file the note of submissions and memo of citations if any within a week.
Another to it application you will not see me disposal. Appointment is given, but
only one submission, my lord. There I placed a matter, my lord, that the collector had taken a decision that DSW has sought for clarification from the government, awaiting a clarification from the government. So the repentation of the petitioner was disposed of. My lord, annexure A/6 to the counter in the present writ petition, that is first writ 25094, is the clarification of the government.
Annexure 9 is not.
Yes.
Annexure 11 is also challenge.
Enough.
Item number 16.
Permitted to withdraw.
For P7, my lord, our name may be reflected in ours.
Achito. Yes.
Item number 17.
Item 17. Pass over.
Item number 18.
No instruction disposal. 17. See, same order about 17 no instruction. 18 no instruction.
Item 19.
For the opposite party on behalf of Dr. Jekyll, the Lordship file actually has been displayed, but I've gone through the.
Pass over. You are not the petitioner. Wait. Let the petitioner come. We'll see.
Item number 20.
20. Pass over.
Item 21.
Pass over.
Item 22.
Legislators. Petitioners, the batch of petition. First two petition, both the petitioners are the Anganwadi workers. They are engaged in the year 2011. Annexure page 9. Lordship may take up 1 to 283. 1 to 283.
128 seems to be 18282 ଅଛି
18283.
18283 yes.
Annexure is the order of engagement on 11/7/77/11.
Annexure 9.
Annexure 1 page 9.
Annexure 1 page 9. Miran Moi Paikra. Yes.
Joined in next page on the 15/7. While she was continuing, a mishap happened that the wall of the Anganwadi center where it was continued, they collapsed in the Nayagad. That is a very difficult story created. For which annexure 3 page 12 issued the show cause. Sub-collector issued the show cause 11/7/2. Only they are in the 3 points, my lord.
Hmm.
9/7 ତାରିଖରେ ସରକାରୀ କାର୍ଯ୍ୟ ସମ୍ପାଦନ ଅବହେଳା ହେତୁ କାର୍ଯ୍ୟରୁ ବହିଷ୍କାର ନିମନ୍ତେ କାରଣ ଦର୍ଶାଅ ନୋଟିସ୍। ଅଙ୍ଗନବାଡି କ୍ଲଜ 1 ଅଙ୍ଗନବାଡି କେନ୍ଦ୍ରର ପ୍ରାଗୃତିକ ଶିକ୍ଷା ଏକ ଅସୁରକ୍ଷିତ କୋଠରୀ। 2ରେ ଶିକ୍ଷାଦାନ କୋଠରୀରେ ଅସୁରକ୍ଷିତ ସତ୍ତ୍ୱେ ଏହା ଉଚ୍ଚତର ଦୃଷ୍ଟିକୁ ନ ଆଣିବା। ରୋଷେଇ ଶାଳାରେ ପିଲାଙ୍କ ରନ୍ଧା ଖାଦ୍ୟ ଦେବା ବାରଣ ସତ୍ତ୍ୱେ 9/7 ତାରିଖରେ ରୋଷେଇ ଶାଳାରେ ପିଲାଙ୍କ ଖାଦ୍ୟ ଦେବା କାନ୍ଥ ଭାଙ୍ଗି ତୁମ୍ବର ଗୁରୁତର ଅବହେଳା ଓ ଆଦେଶ ଅବମାନନା ହେତୁ 6 ଜଣ ଶିଶୁଙ୍କ ମୃତ୍ୟୁ 5 ଶିଶୁ ଆହତ। ତେଣୁ ଉପରୋକ୍ତ 30 ଦିନରେ I short for certain document that is under annexure 4 page 13.
Yes.
ମୁଁ ମିରନ୍ମୟ ପାଇକା ସଚାଂଶ ଆପଣଙ୍କୁ ନିମ୍ନର କେତୋଟି ଧାଡି ଲେଖି ଅନୁଗ୍ରହ ପୂର୍ବକ ଜଣାଉଛି ଯେ ମାଗିଥିବା କାରଣ ନୋଟିସର ଉତ୍ତର ଦେବା ପାଇଁ ନିମ୍ନରେ ପ୍ରଦତ୍ତ ଆବଶ୍ୟକ କାଗଜପତ୍ର ଯୋଗାଇ ଦେଲେ ମୁଁ ଉକ୍ତ କାରଣ ଅନ୍ତର୍ଜନ ଉତ୍ତର ଦେବି। 1 ଅଙ୍ଗନବାଡି କେନ୍ଦ୍ର ପ୍ରାଗୃତିକ ଏକ ଅସୁରକ୍ଷିତ କୋଠରୀରେ ସମ୍ପାଦନ ହେଇଥିବାର ଓ ଉକ୍ତ କଥା ନ ଜଣାଇବା ପାଇଁ ଯେଉଁ କୈଫିୟତ ମଗାଇଛି ଏ ବିଷୟରେ ଆପଣଙ୍କୁ ଜଣାଇବା ଉଚିତ ମନେ କରି ଉକ୍ତ କୋଠରୀଟି ଅସୁରକ୍ଷିତ ବୋଲି ଘୋଷଣା ହୋଇଥିବାର ପତ୍ର ଏହାର କାହା ଦ୍ୱାରା କେବେ ଅସୁରକ୍ଷିତ ଘୋଷଣା ହେଲା କରାଯାଇଛି ତାର ଉପଯୁକ୍ତ ପ୍ରାମାଣିକ କାଗଜପତ୍ର ଦେଲେ ଆଶା କରୁଛି। 2ରେ ଶିକ୍ଷାଦାନ କୋଠରୀରେ ଅସୁରକ୍ଷିତ ବୋଲି ଉଚ୍ଚ କର୍ତ୍ତବ୍ୟକୁ ଜଣାଇବା ପାଇଁ ଆପଣଙ୍କୁ ଥିବା ନିର୍ଦ୍ଦେଶନାମା କାହା ଦ୍ୱାରା ଅଧୀନକୁ ଦିଆଯାଇଛି ଏହାର ଏକ ନକଲ ଅଧୀନା ଶ୍ରୀ ହଜୁର 3 ନମ୍ବର ଆପଣଙ୍କର 3 ନମ୍ବର କାଣ୍ଡ ପ୍ରଶ୍ନର ଆପଣଙ୍କୁ ରୋଷେଇ ଶାଳାରେ ଖାଦ୍ୟ ନ ଦେବା ପାଇଁ ଦିଆଯାଇଥିବା ସରକାରୀ ନିର୍ଦ୍ଦେଶନା କପି ଏଥିରେ ଦର୍ଶାଇ ଯାଇଥିବା କେଉଁ ଅବହେଳା ଆଦେଶ ଅବମାନ ସମ୍ପୂର୍ଣ୍ଣ ଚିଠି ନିର୍ଦ୍ଦେଶନାମା ଯେଉଁଥିରେ ଅଧୀନ କେଉଁ ନିର୍ଦ୍ଦିଷ୍ଟ ଆଦେଶର ଅବମାନ କରିଅଛି କେଉଁ କାର୍ଯ୍ୟ ଅବହେଳା କରିଅଛି ତେଣୁ ଏ ତାର ଯୋଗାଇ ଦେଲେ ଶୋକସ। It has received through post, it has sent received. Then your lordship may ଆପଣଙ୍କୁ ଶିକ୍ଷାଦାନ କରିଥିବା ଅଙ୍ଗନବାଡି କେନ୍ଦ୍ରଟି ଅସୁରକ୍ଷିତ ବୋଲି ଘୋଷଣା same thing reiterate. Then your lordship may annexure also I again reiterate this to provide
The documents. Yes. Then
annexure 7 your lordship may kindly disengagement issue straight away. A Anganwadi worker joined only 11 months. He was provided the house where it was shown to by the authority to run the center. Unfortunately, due to heavy rain that collapsed, it is an unfortunate act. Then I have suffered for that since 2012 till date.
no injury to anyone?
And in 7 was died.
Who? Satara pila mari gale.
କାନ୍ଥ ଗଳି ପଇଲା ପୁରା ବସିଥିଲା।
Choto pila?
ଏମାନେ 2 ଜଣ ଦୌଡ଼ି ଗଲେ।
Eh?
ଏମାନେ ଦୌଡ଼ି ପଡିଲେ।
ନାଇଁ that is not ଦୌଡ଼ି ପିଲା allegation ସେଥିରେ ବି ଲେଖା ହେଇଛି ତମେ ଟାଣିକି ବାହାର କଲ ଅନ୍ୟମାନେ ପିଲାଙ୍କୁ ସେ ରିସ୍କ ଲେଖା ହେଇଛି। Their counter they are saying my lord your lordship make a glance I was absconded. Their counter your lordship may kind of glance to internal test counter. All those post-incident facts have been informed. Para 7 that reply one to the petition is humbly shown that keeping in view the instruction of government 2/9/2009 instruction was given to all headmasters headmistress by the collector chairman Sarva Shiksha Abhiyan Noyagarh letter dated 25/6/2010 the Sarva Shiksha Abhiyan Noyagarh to run all Anganwadi centers in primary school building. All the headmasters were also specifically instructed to hand over the key of one classroom to the Anganwadi worker to facilitate running. But nowhere it is communicated. It was where it was allowed to continue. New building constructed, the school is shifted to that. We are continuing there. Then you will also make para next page 3. It will humbly submitted there, starts from Swansea Anganwadi Center established on Onesota and it was functioning in the old GIC building. Swansea Primary School building since 2010. New primary school building Swansea Primary School constructed under Sarva Shiksha Abhiyan during the 3-4 with estimate cost of 4.5 lakhs. 4.5 lakhs was completed in the 2006. Swansea Primary School was functioning newly constructed building Swansea. Anganwadi Center was functioning in the veranda of the school building. The Anganwadi post of Swansea was laying vacant due to promotion of Lakshmi Kumari Sahu, Anganwadi ex-Anganwadi to the post of lady supervisor during those. The petitioner was engaged to Anganwadi worker Swansea Anganwadi Center on 7/7/2011. CDO joined in the post on 15/7/11. After her joining,
She started functioning new school veranda with 6-7,2011. It is submitted during that period 240 Anganwadi center under the Aranapur Social Center. Next, the Anganwadi workers Anganwadi were instructed that time they were instructed not to use the unsafe dilapidated house school building for preschool, kitchen or dining purpose under SNP program, and to restrain from students from entering into that old building till the demolish. Let them, they have not filed a single document. What is the what document they have? Because in 15 days, the supervisor has to visit. In 1 month, center inspection is made by SUDPO. What report they have prepared? If that would be the shown by the petition, then how the petitioner is responsible for that? It is the unfortunate act. I do concede to that, and it is not within the control of anybody. The petition is suffered in 2012, disengaged without any alter. In a PIL, my lord, what a PIL was filed, their counter was filed is there by the state. What they have mentioned, the lordship, glance that I have enclosed to my writ petition. Page 31, running page 31.
Of this writ
petition. The PIL file for compensation towards the death. Page 31, report of the prayer of the applicant, para B. There is state the counter is filed. Collector. It is reported by the Anganwadi worker that para B, capital B, report of the prayer of the applicant.
in High Court. Annexure 9 to?
Annexure. Page 26 to 36. Page 31. Annexure 9.
Of this writ application 18283.
18283.
Page 31 रे तो G बोली किसी नहीं. Abstract अच्छी तब children return home after treatment at area.
Started page 26. The counter affidavit started from page 26.
No. You are referring to some other. Counter affidavit starts at page 27.
In WPC 12553. WPC 12553.
12553.
What a PIL जो है.
12553 is the counter term decree.
हाँ.
By Sashikanta Chaudhary.
My lord. Say page 31 जो starts.
चाहिए अपना paragraph का कौन?
Capital B.
Capital B किसी नहीं?
Page 31. That is para 11, para 12. That is the regard to prayer.
हाँ, page 33 ले जाएं पहुँच लेने. Yes.
It is reported by the AWO or Anganwadi worker that administration of Swasai Primary School did not allow the Anganwadi Center to function in the formal school building, nor also allowed to spare a veranda for the function in the Anganwadi Center. So under duress, the Anganwadi worker of Swasai and Kadam Sai were functioning in the corridor of the old dilapidated GIC roofed room. Cooking was organized in the room, the wall of which collapsed. So Anganwadi worker was established during unnecessary such and such. So it is there. They were not provided this school building. They are allowed to run the school in the old house, the GI house.
This court would like to know what action was taken against that headmistress.
They suspended procedures of again exonerated.
I'll get that instruction, my lord. With respect to this particular case, my lord. Now, the submissions what we have made in our counter.
No, that I will see, but I would like to know. Because the Anganwadi worker, to my knowledge, does not decide where the Anganwadi center will be located. And you have, whatever Mr. Mahathir has shown me from the pleadings, from your counter, is that there were some instructions or some direct guidelines issued by the government directing all the headmasters and headmistresses to provide rooms for functioning of the Anganwadi center.
Yes, ma'am.
Here also, in this paragraph B, it is reported by the Anganwadi worker that the headmistress of Swasya Sahi Primary School did not allow the Anganwadi center to function in the formal school building, nor also allowed to spare the veranda for functioning of the center. So under duress, it was being held in a corridor dilapidated GI sheet. What could she have done?
Yes, madam. But the present counter says matter otherwise. My count, this counter. Affidavit. What
There
I-
cannot be two different stands
No, no,
taken by the state.
I know that, but.
You have to prepare again. Mr. Patnaik, no, you come up with a comprehensive, Mr. Patnaik, you come up with a comprehensive stand.
Yes, ma'am. Yes.
That is one part. Second part, as he has also pointed out, when the Anganwadi center functions, the supervisor makes a visit, including the CDPO.
Yes,
So there must be some reports.
Yes.
Why have they not pointed out that it is functioning in a dilapidated building? It may cause danger to the children. And in fact, this is what happened. 7 children lost their life.
But my lord, here in this
The
case.
question is, can this lady be blamed?
Yes.
So see, she's being made as this scapegoat. That's all.
Here in this case, my lord, our stand is different.
What is
That
this?
these Anganwadi centers were allowed to be operated in the newly constructed building.
So
there was no question to further go to that particular old building, man. For the Anganwadi.
there was a building available.
Yes, new building was and the space was provided to them.
So why did they go?
That is, my lord.
What was the reply? Explanation?
No, they have not filed any rejoinder to this one.
No.
We have made a specific argument to this one.
Let us see a show cause. Where is the show cause? Show cause से कहता लिखा ही जी. Show cause रे अपन तुम कौन सी जिंदगी जे नया बिल्डिंग से तुम कहीं जाइनो बोली.
सब मैंने सही थी कहीं कोरुतले बोले हम सही थी.
नहीं, बर्तमान अपन you are saying that there is a new building was available.
ये मतलब that is what मतलब now it has been placed before Lordship, but only in piecemeal manner. So the rest portions that have not been present before Lordship.
No,
In that particular count.
you have not completed your argument.
My particular submission, my lord, in this case is that, my lord. Initially, my lord, that was actually continuing in a school building. But later on, my lord, after the construction of the new building, a space was provided.
So who's to decide that? Where the Anganwadi center will function, who's to decide that? Certainly not the Anganwadi worker.
No, my lord, but there is already communication according to them, my lord. The stand of the counter.
Communication to whom? Communication to whom? That is what I would like to know.
Page 22 counter make like that.
Wait.
Yes, ma'am. Then in that case, man, I will get that particular update instruction to that.
Yes. So communication जो नहीं थी communication कहाँ पे थी? Unless you come up with a specific case saying that this particular worker was debarred or asked not to hold the school or Anganwadi center there,
Yes, ma'am.
despite which she continued with that.
Yes, ma'am.
So how can you say that she is responsible? This court would like to know that. This is a very sensitive matter. 7 children lost their lives.
Yes.
So whoever is responsible must be punished, but whoever is innocent should not be punished.
Yes.
That is more important. Hard and fast?
But page 20 the counter.
hard and fast.
नहीं, I'm just like.
No.
9 तारीख रे incident, 17 तारीख 27 रे after 20 days they are communicating to headmaster and block David.
Hard and fast. This matter. When can you be ready with a comprehensive
Yes, ma'am.
note? I don't want you to file any further.
Second week of September, ma'am.
I don't want you to file any further affidavit.
Yes, ma'am.
Enough. I think he has also given whatever all the documents are on record.
Yes, ma'am.
So you have to come, both of you come with a detailed date chart and note.
Yes, ma'am.
Incorporating all the facts.
Yes, ma'am.
As you have yourself said, not in a peaceful manner, number one. Number two, as it appears, your counter in the PIL and your counter in this case, there seems to be some kind of a discrepancy. So you have to
Yes,
reconcile everything. Right. Heard in part, is this matter? On 18th September.
18th September.
Learned Councillor requested to come ready for final disposal.
Yes.
Item 23.
There are 4 matters, Mr. Manti?
Yes.
All the 4 same?
Same.
All.
Both we have 2 worker, 2 center adjacently functioning and 1 is the helper.
Yes.
Sir, this is the third round litigation of this petition.
23.
Yes, 23.
Yes.
First, it was in the year 1998, OJC 12348 of 1998. Thereafter, a writ appeal filed, that is writ appeal 32 of 2005. After that, this third writ application has been filed. Now, 26 years have passed in the meantime. I want to know this, you want to proceed because this is Anganwadi worker. Whether by this time, whether she is willing or she has gone anywhere. I just some 7 days or 10 days time because I have got it today morning. I wanted to know
I'll call it next week.
Sir, last week don't. By that time, she was a miss then, now might have been a missus. I don't know this or not.
On 11 September, as requested by Learned Counsel for the petitioner. Yes.
Item 24.
Sir, that rule, sir, 22 ટારે હું just 21 ટારે હું rejoinder ready કરી ଦେଇଛି ଖାଲି swearing ହେଇ ପାରିଲାନି because he is yelling. Sir, ସେଇ ଦିନ ଏଇଟା ବି 21
Item 21. Item 21, list this matter on. That is
11 September.
on 11 September, rejoinder be filed in the meantime.
Item 24.
Item 24, my lord, and for the opposite party number 3 and 4, I may be permitted to file counter in this case.
Petitioner is not there anyway.
Not
You are there, all right.
on behalf of
Sri Mr. and Counsel for the opposite parties wants to file counter. Yeah, 2013 matter.
my lord.
How did I file counter?
One matter has already, your lordship has given judgment in the last year. My name does not reflect in that order.
In the judgment?
Yes, my lord.
No,
Therefore, I pray, my lord, in this case.
no, I'm sorry. I'm really sorry. This, because as a lawyer, I have suffered for that. Positively.
Interim order to continue.
Interim order to continue.
Item 25.
Filing the region affidavit to the counter of opposite party.
You are filing rejoinder?
Yes.
All right.
My lord, I'm ready.
You want time or?
No, my lord, I'm ready. My lord,
You are ready?
I pray one thing, my lord. You lost my call for the record of the additional district magistrate.
Of the?
Additional district magistrate, ADM, who had decided the appeal, my lord.
This is an Hon'Ble matter.
Hon'Ble matter. Because, my lord, I have taken a that no notice was issued in the appeal to me.
All right, we'll call for constance.
No, my lord, before that, my lord, the impugned order is clear.
They
record-
said that I have been had, but no notice has been.
He's taking it specifically, we'll call for. दूध का दूध पानी का पानी हो जाएगा.
As a lordship, please.
दूध का दूध पानी का पानी हो जाएगा.
As a lordship, please.
Why are you worried?
They're enjoying a stay order against my job, so that is why.
Sure, 2015
14 merit list.
My lord, but they were not a part of the Anganwadi. It was my right to claim it.
Try to learn the tricks of from seniors like Mr. Mahathir. Sri Mahathir and counsel of the petitioner files rejoinder in the court after serving copy on the other side. Same be kept on record. Sri Mahathir further submits that despite an endorsement being made in the impugned order that his client was heard during hearing of the appeal, yet it is a specific case that no notice of the appeal was ever served on his client. Stop. In order to appreciate the contentions, it is necessary to peruse the original file maintained by the appellate authority. The State Council is directed to produce the file positively by the next date. List this matter on
18th September.
18th September.
Interim order to continue.
Interim order to continue. A copy of this order, free copy of this order be handed over to the State Council for compliance.
Item 26.
Gratefully, lordship.
26. Anybody?
Your lordship can pass over, your lordship.
All right, pass over.
Just you are the launch, your lordship.
Pass over. After launch, no, pass over to देखिए जितने लोग यहाँ रखा हो.
Item 27.
27, yes.
Here is a matter related to selection of Anganwadi helper. Here the petitioner has filed this.
I can take it.
Here the petitioner has filed this application challenging the selection of OP number 5 as Anganwadi helper.
Who is appearing for opposite party number 5?
Yes, sir. They are not present.
Counter rejoinder filed. Quote. You begin.
But here the petition challenge selection of number 5 as Anganwadi helper in Atlaspur Anganwadi Center. But prior to this writ application, the petitioner has filed another writ application that is 6031-19. This one is disposed of. That they give finding that both the collector and solicitor has no power to hear the matter. Then either the sub-collector is the appeal authority nor the collector. That is, but the sub-collector is the authority of to hear the matter.
So I had approached for the sub-collector against the selection of opinion 5. Because the opinion 5, neither he says belong to the central area, nor says AC. This center is completely predominated by the scheduled caste candidates. So the petition being belong to central scheduled candidate, she is entitled for that post. That is why I had but the CDPO illegally selected the opinion 5 as in that center. That I had challenged, and this Honorable Court that rejected that on the ground that it's called sub-collector that passed order in my favor. But against that order, the opinion 5 approached the collector. Collector stayed the matter. They agreed. I filed a writ application, and this Honorable Court said that both collector and sub-collector no power. But sub-collector is the authority to hear the.
So now what is there?
But now I have challenged that since the sub-collector is the authority.
So then you will have to file an writ appeal against that order passed by the single bench.
But the government said that.
Maybe, but how can it be ignored? If there is a judicial order. Yes, what you said. It can be ignored. It can be decided per inquiry.
Yes.
It can be. This court can hold it as having been decided per inquiry. If you can show me, if he can show me the rules. If the statute says something and this court says, I have passed similar orders.
Yes.
Ignore saying that the statute says something else,
Yes.
divisional bench says something else. So that can be done, but provided you have to come out with the case. So you are, let us see, you are one of the applicants.
Yes.
Where is the order of selection of opposite party number 5?
That is.
I'm reading them.
That order is not there, but the sub-collector order, the annexure 2, the annexure 2.
Yes.
That the case today, the Honorable High Court passed dispose the application, so and so, and directed the sub-collector through here to dispose of the Anganwadi miscase number so and so, and pending with him by the order so and so. Passed the Honorable High Court in WP. This said Anganwadi miscase number of 2018 has neither been initiated nor pending with this court. So the Anganwadi miscase has been instituted for implementing the orders, spirit of order cited so and so. Passed by the Honorable High Court, Odisha for consideration of the grievance of petition filed in the petition after giving opposition hearing to all concerned. Petition has alleged that the
Mr. Patnaik. So this order was passed by the sub-collector.
In my favor.
Yes. Then in your favor means it says that she is directed to convene fresh Mahila Sabha. Fresh Mahila Sabha.
Yes. Then the she was selected. Being agreed with that order, the opinion 5 preferred appeal for the collector. Collector stayed the order, sub-collector.
So you came to this court. So this court said
that the both collector and sub-collector not
to selection neither the sub-collector nor collector jurisdiction. We have to file a counter in this. You have filed a counter.
We have filed it. We have filed a counter, my lord, and we have enclosed a copy of the selection proceeding, my lord. That is Annex 3/4.
So what now? This court holds that neither the collector nor the sub-collector has the jurisdiction. So who has the jurisdiction? It is the ADM. It is the selection.
With respect to the Anganwadi helpers, my lord.
Helper is sub-collector, was it? Sub-collector. So this order was passed.
The new guideline also, my lord.
The sub-collector is the
sub-collector, and the second appeal is.
This will be under the 25/2007.
No, that is under the Anganwadi helper, my lord. That is of 1997.
97.
25/2007 is exclusively for the Anganwadi workers.
So you should have filed a writ appeal. So what is your stand?
The stand, my lord, what we have taken, my lord, if your lordship will come to Annexure 3/4, my lord, at running page 8 of my counter.
The selection proceeding meeting.
The selection proceeding, my lord, where the Mahila Sabha was there. More than 1% of the applicants were there. 4 number of applicants. If your lordship will come to page number 9, the name of the 4 candidates are there. Voting procedure was adopted as per the practice. And thereafter, my lord, out of 261, Janakara Nako Chechi, ହଉଛି 262 ଜଣଙ୍କର ନାକଚ ହେଇଛି 261 କୁ ଭିତରୁ ମମତା ମଲ୍ଲିକ she got 104, Arti Das she got 107, Asan Malik 35 and Urmila Das 15. Opposite part number 5 টা କୁ ସେଟା selected, opposite part number 5 হচ্ছে Bharti Das. মানে getting the highest vote, that is 107.
So now what are you challenging?
But I have challenged the selection, but the petitioner is
Mr.
belong,
Naik?
is a select caste person.
No.
Let.
I have understood here. You had once challenged. All right. Sub-collector passed an order in your favor.
Yes,
The opposite party number 5 went to the collector.
yes.
Okay, either the sub-collector nor the collector is competent. So thereafter, what can he do?
But the selection I have challenged, the selection is completely illegal.
How can you ignore that order passed by the single judge? That order is there, staring at you. You should have filed a writ appeal against it.
That technical is there.
The technical consider the main.
I know that too. But why I am challenging here?
How can this court assume jurisdiction when the matter has already been disposed of? Will the adjudicator not apply?
In that point of,
Tell me.
that technical is.
There are-
Let's may permit for file a writ appeal with details. But the.
Writ appeal now, it is too late.
Let's.
Too late in the day.
Sir, মানে practical যেহেতু সেদিকাস এটা তার স্যার 97 গাইডলাইন কହୁଛି the person should first preference will given to the person
You are right.
which belong to that area.
You were right. You may be having a good case on merit, but how can this court assume jurisdiction?
That point
That order was passed kebe? Way back in
2018 and the order
2019. 5/4/2019.
5/4/2019.
Thereafter, she may have been appointed also. Opposite party number 5 may have been appointed.
সেই সময় আপন পাইগলা সেই সময় চ্যালেঞ্জ
Now reopen the case. How can you reopen the case? You should have challenged the single judge's order before the division bench.
I said that technical.
That's a completely wrong thing. Instead, you file another writ application. That too also in the same year, in 2019,
Yes.
instead of filing a, yes, what do you say? When was the writ application filed?
That is, our record says my lord, it is
25/4/2019.
2019.
Today, when was the order passed?
19/4.
5/4/2019.
5/4/2019.
So within 1 month, he has filed another writ application instead of filing a writ appeal. You may seek withdrawal. No, I will just observe, make your observe. I cannot grant liberty to file to a higher forum.
Yes, sir.
For lower forum, I can. For higher forum, I cannot grant you liberty. I will just record your submissions, including the submission regarding consideration of delay. That I will also.
Yes, that lots may object that technicality is there. No,
No, call you, Monica.
yes, that on that point I have nothing to say.
No, call you.
In modern merit, I have good case.
Yes, the petitioner was an applicant. No, in course of hearing, Sri C.R. Patnaik, learned counsel for the petitioner, seeks permission to withdraw the writ application as he intends to prefer a writ appeal against the order passed by a coordinated bench in WPC number 6030 of 2019. And according to whom the same is contrary to the guidelines issued by the government relating to the competence of the sub-collector to hear appeals against selection of Anganwadi helpers. Sri Patnaik further submits that the order was passed by the coordinate bench on 5/4/2019 and the writ application was filed, and the present writ application has been filed on 25/4/2019. That is within less than a month. Stop. He therefore, therefore notwithstanding the fact that the present writ application remained pending till today, he should be allowed to, he should be permitted to withdraw the same in order to prefer writ appeal. Stop. Considering the submissions as above, the writ application is permitted to be withdrawn with liberty to the petitioner to seek appropriate legal remedy. Yes. Yes, Mr. Patnaik? I think that will help him. This observation.
Item 28.
So when you seek condonation of delay, you have to point out that you have filed within 1 month. Within the period of limitation, you have preferred this appeal. Rightly or wrongly?
Right.
Shirka likhi jo to. Wo likhi le jo yes file on 25/4/2019. Apparently on wrong legal advice.
My lord, in that item number 28, my lord. As I,
Yes, you want a time.
my lord. Yes, my lord. This matter may be taken up next week.
Next week.
Yes.
You'll be ready with the.
No, today, my lord, I have not received that file.
As requested by Learned State Council, this is matter next week.
Yes.
Item 29.
Passover. बहुत passover है जी ना.
Item 31.
Yes, my lord, the last time my lord, my lord filed counter affidavit, my lord. I also took time to file rejoinder, but because of inconvenience, my lord, rejoinder after not filed. So which time may be allowed? Last chance.
As requested by Sri Satpathy Learned Counsel to the petitioner, list this matter on 11 September. Rejoinder, if any, be filed in the meantime.
Item 32.
May I please, your lordship. I have filed a writ application challenging the arbiter order removing the petition of the post of Hon'Ble helper, my lord. The lordship may turn to annexure 4, page 16, my lord.
You have filed, you have not filed appeal.
Pardon, my lord?
You have not filed any appeal.
No.
File an appeal.
No, the thing is that when I am continuing with the after appointment order, I am continuing with that. After 6 months, suddenly the one lady candidate who was contesting filed the SSW filed an application before the collector that I have got BA qualification and 5 mark should be added to me. Though I have made parties, the notice has not served upon me, and I am not allowed to participate in the hearing. And basing upon that, they have removed him from service, my lord. Your lordship may see the annexure 4, my lord. Page 16, my lord. The comparative statement, my lord. The comparative statement shows at page 16, my lord. The second, Susmita Behera. Her qualification is intermediate. And the percentage of mark is 48. Then I am at serial number 5. Anjana Behera. My qualification is intermediate, but I have secured 48.5. Basing upon this comparative statement, I have selected. While I am continuing at the authority given me appointment, I am continuing for 6 months. Suddenly, on basing upon the complaint before the annexure 1, order number 226 dated 15/4/2024 at page 11, my lord. Your lordship may say.
Okay.
मान्यवर सब कलेक्टर बालेश्वर निर्देश अनुसार SSW मिसकेस नंबर 16 केस अध्यक्ष मुताबक 15/4/2000 अपराह्न कार्य अंतर करागला.
You are not a party in that case.
Though I have made parties, but no notice, nothing has been served upon me. Your lordship may turn to that annexure 6 at page 17, my lord. Your lordship may turn to counter, my lord. They have filed that order at page 6, my lord. Page 6 of the counter.
Yes.
Page 6, paragraph 2, second paragraph. The Lord and Advocate of the petitioner. Petitioner here is Susmita Behera. Advocate appellant has appeared in this court through Okalatama notice he has filed requisites from which part of the case record the child development CTPO Bosta respondent who has appeared in the case notice. She has filed submission which forms part of the record. Srimati Anjana Behera, AWH, the petitioner. A respondent who has not appeared in the court despite of notice. Simply they have set a despite of notice.
What is the file?
Yes.
File.
While this case is pending in the writ application pending, the authority has given appointment to that Susmita Behera. So, in spite of your lordship's interim order.
Yes.
Interim order, yes, my lord. Your lordship granted interim order on 13/5/24, my lord. Appointment order.
5/8/2020.
On 5/8/2024, my lord.
In course of hearing, it is brought to the notice of the court that despite an interim order passed by this court 13/5/2024. No, I have only said that any selection made shall be
Subject to result.
subject to. There is no prohibition. That will abide by the result of this writ application.
They have filed counter. They have instructed that the case is pending. Still then,
They will suffer.
they have got the appointment.
No, it doesn't matter. What we will do is I will only take note of your submission that you are not given any notice of hearing.
Yes, madam.
So let him produce the file. In course of hearing.
After 6 months, my appointment after 6 months.
Just let me discuss.
Okay. Yes.
It is in course of hearing, it is submitted by law and counsel for the petitioner that though the impugned order mentions that notice was issued to the petitioner for hearing, yet no such notice was ever served upon her. In order to appreciate the contentions better, it is necessary to peruse the file maintained by the. It is necessary to peruse the concerned file of the. Where is that order?
The origin annexure A/4
In SSW.
SSW.
I guess ticket, please. In SSW, Miss Case number 3 of 2024 of the sub-collector Baleswar. The State Council is directed to produce the file.
Yes.
The entire file, including the order sheet. For perusal of the court, list this on 25th September. Yes.
Para number 3 of our counter, madam. If it will not be sufficient, then the petitioner has filed an aforesaid writ petition of the honorable challenging the arbitrary order and removing her from the post of the Anganwadi worker. So, para number 6, madam. That in reply to averment in para number 3 of the writ petition, it is submitted a notice was issued to both the parties on 13/4/2024 by the sub-collector Baleshwar to attend the court of sub-collector Baleshwar. Opposite but number 2 on 20th March 2024 hearing of SSW misconduct. But the petitioner did not receive the notice claiming to be ill and failed to attend the court on for which hearing of the case was postponed. Thereafter, the sub-collector Baleshwar after perusal of the record passed. So, this is the admission.
যদি সে রিফিউজাল করতে ই রিফিউজাল নোট করি কি এন্ডোর্সমেন্ট হেতান্তা রিফিউজাল তাহলে ই নোট করি কি কনফিউশন করতে
So, this is
যদি এই কেস এলা হি রিফিউজ অ্যাকসেপ্টেবল ফিল করলে আউট নোটিস করতে
So, this is the admission whether if your lordship feels it appropriate to peruse the record once more.
Still then you produce the record. You never know, you produce the record. Yeah, counter লিখলে কোন লিখতে হবে জানিয়ে কষ্ট রেকর্ডটা দেখলে রেকর্ড will speak for itself. Interim order to continue.
Deep blue bridge.
Item 33.
May I please? Last occasion, my lord, direction to the notice has been issued to all the opposite parties. And the direction to the directed to the State Council to obtain instruction about this.
We have received the
relevant records relating to the joint inquiry.
my lord, we have received a Paravesh comment in this case, my lord.
Yes.
We will file the counter very shortly.
And along with the records, I will ask you.
Along with
Ask you
the
to obtain necessary instruction, also produce the relevant records.
we will produce the records. On 11th September, my lord, this matter will be taken up on that day. my lord.
Sri S. N. Patnaik, learned AGA, submits the necessary instructions and Paravo's comments.
Yes, ma'am.
And requires some time to file an affidavit.
Yes,
Let this matter on 11th September, the previous order be complied with.
yes.
My name, my name is, my name
What is your name?
PC Das, Prakash Das.
ये previous counsel को अपन नहीं चाहती कि no objection नहीं appear कर चल.
No, I am appearing on behalf of Mr. Rai Mills. Mr. Rai Mills.
So your name is not necessary.
Miles.
Item 34.
Hon'Ble.
Number 34 is the transfer matrimonial from Padmapuर to Patnagar. Last time the mind I already directed to lower court to submit the report. The letter has been come, is a flag B. The notice has been served to twice to the opposite party, he is not appearing. Transfer.
The letter of the senior civil judge Padmapur reveals that both Hemanta Behera, bracket opposite party, and his counsel have been informed by letter dated 3/8/2024 regarding pendency of the present case before this court. Further, on 23/8/2024, the counsel for Hemanta Behera, bracket opposite party, submitted in writing before the court below that he has intimated the fact of hearing of the present application to the father of Hemanta Behera through mobile. Stop. The number of the mobile phone has also been indicated. Stop. The above proves that the opposite party has intimated of the pendency of the present case. They duly intimated about the present case. Continue, in spite of which he has chosen not to appear. As such, notice is held to be sufficient on the opposite party and the transfer application is taken up for hearing. Yeah. Transfer application allowed. Yes.
Item 35. No. Here for transfer of the matrimonial.
Mr. Salogi?
Sir. There are two applications, one at the instance of wife and one.
Both are here, both have been listed.
Yes, both have been tagged. One at the instance of wife and.
Best way to this is if you can settle it.
Is that conciliation was taken place, but it has been failed.
It has failed.
Wife is working at Bhubaneswar. Husband has filed an application for under section 9 of the Hindu Marriage Act for restitution. Wife has filed an application for divorce at Bhubaneswar, Learned Judge Family Court. So I pray for transfer of that restitution case from Bari to Bhubaneswar.
The other case you filed.
Bhubaneswar to taking transfer for Bhubaneswar application to Baripada. Here the husband is 61 years old, having no permanent source of income. The wife is a government servant. And before institution of the proceeding at Bhubaneswar, she had instituted a proceeding of divorce, same proceeding at Baripada, contested the case there. The same was dismissed.
Mr. Dwivedi,
yes, sir.
Your application is rejected, his application is allowed, you will be granted a virtual hearing.
Yes, my humble assumption, the GC facilities are available in both the places. Only one submission of mine may be recorded that earlier he had instituted proceeding at Baripada and he fully attended. Say what I can
merit of the case.
First transfer application allow kar do. ये तो खाली गोटे लाइन लिखियो श्री एसके द्विवेदी लॉ एंड काउंसिल फॉर द अपोजिट पार्टी husband has opposed the prayer for transfer on the ground that here an application was filed at Baripada in which the petitioner wife had appeared. सुनिए तापर हम भी ऑर्डर आला कर आरटा
C filed man.
हां हां
Yes.
आरटा रे देखो रिजेक्ट कर दो रिजेक्ट कर दो क्योंकि तो वर्चुअल हियरिंग जो टाइम हो
Virtually not to insist. Yes. And it may be time bound. Or for 2020.
ये बगा बाटा
Yes. Twenty-two.
So you want it to be, I mean, this matter will be decided by Bhubaneswar.
Yes.
Difficult.
That
Very
courts are functioning.
The two courts, each court has 4,000 cases. And we need two more courts. You don't have officers.
Yes.
Only
Very
one-
difficult. So I will not target.
One prayer mail in TRPC 4/12 of 2023 filed by the petitioner. In the cost title, that is wrongly typed as that she is working as constable in OISF. That I to correct the same by filing a consolidatory cost.
Yeah, I think second
That's
matter
about-
today. I go before final order counsel for the petitioner is permitted to. Can you not make it here?
Yes, ma'am, I can.
Is permitted to correct the typographical error in the cost title of the transfer application in court.
Yes.
Item 36.
Present petitioner and the wife filed an application before the Honorable Court for transfer of the CP proceeding number 587 of 2023 from Lawrence Judge Family Court to Bhubaneswar to Kendrapada.
What instructions have you obtained regarding mediation?
Mediation, they are not agreeable, my lord.
I don't know. Last time,
No.
last time, both of you took time on the ground of obtaining instructions from your client. What is your instruction?
We agree to transfer the matter to.
No, my lord, he not for settlement and not for conciliation. So that was my instruction.
No. You don't agree. Your client doesn't agree for settlement.
No, I did not talk. Lordship may send the record to the mediation center. And he agreed to transfer the judge family court, but targeted.
Another thing, if you have no objection to the transfer, I'll transfer.
But let it be transferred with a time schedule, my lord.
All right. The transfer allow कर दो, allow करके लिखियो the judge family court केंद्रापड़ा shall try and dispose of the case as expeditiously as possible, preferably within 6 months.
I mean, permitted to cost title instead of for 2023 year, only days. Only cost title page.
अच्छा, Learned counsel for आगे लिखिए, learned counsel for the petition is permitted to correct the typographical error in the cost title in court. Court करो.
Item 37.
Obliged.
There are two transfer applications, one
Yes.
by husband and another by wife.
One by husband.
Again,
There's a mediation report here.
mediation failed.
Failed.
The husband has refused to.
Anyway, failed.
Mediation failed. କିଛି ଲେଖା ହେଇନି ତା ଦେହରେ ମୁଁ କହିବି ଆଜ୍ଞା ୱାଇଫ ମନା କଲା ସେ କହିବେ ହଜବେଣ୍ଡ ମନା କଲା
It's a failed. I'm not asking कौन पे failed.
ତ ସେଇଥିପାଇଁ କହୁଛି
କହୁଛନ୍ତି ଶୁଣୁଛି କି? Yes.
His my prayer is section 9 petition is pending before the Honorable Senior Civil Judge Holy Court member. That be transferred to Puri.
What is your prayer?
My prayer is that the divorce application filed by the husband at Puri be transferred. I am a resident of Khalipur. It is far away from Puri, and I feel insecure because of certain averments I have taken. So my inconvenience may be taken note, and that is also the.
Same order, you will be the.
Coach, more sir.
Both?
Sir, both of them are working at Bangalore. Software engineer. After my lord, a decree will be passed, appeal lies to the district judge against the order of the senior civil judge. My suggestion, my lord, if subject to acceptance of the lordship, both the matters may be transferred to Bhubaneswar, so that it is convenient for the parties. They are working at Bangalore. It is be convenient for both the parties to pursue their case at Bhubaneswar.
What is it?
So
Not a bad submission, not a bad suggestion.
but instead of Bhubaneswar, it should be Khurda, because your lordship just now said that
Khurda
ହେଇଯାଉ ଖୋର୍ଦ୍ଧା ହେଲେ ବି ତାଙ୍କ ପାଖ ମତେ ପାଖ କାହିଁକି ନା ଭୁବନେଶ୍ୱରରେ ଆଜ୍ଞା 10 ବର୍ଷ ଲାଗିଯିବ।
Bhubaneswar is very difficult. Khurda is no less. Let me tell you.
Yes, but and it will be
Khurda also there is a plan for to have another family.
but it will be more closer.
That's a different matter.
Bhubaneswar airport ରୁ ଓହ୍ଲେଇବେ ଯାଇକି ସେଠି case.
No, I am working. I am not in that corporate sector now. That is a subject to they may dispute.
Yeah, that is it.
So I had to come from Khalikot.
ଦିଟାଙ୍କ transfer application ଦିଟାଙ୍କ club କରିକି ଲେଖ। I'll pass order. I'll pass order. This has to be separately order has to be passed. I'll pass order. लिखी दो नॉले। TRP your matter is 9 of 2024.
More.
TRP 9 of the TRP 9 of 2024 has been filed by the husband of property seeking transfer of MAT case number 14 of 2023 pending before learned civil judge senior division family court to the learned judge family court Puri. Stop. TRPC 350 of 2023 has been filed by the wife of the opposite party seeking transfer of CP case number 260 of 2023 pending in the court of learned judge family court Puri to learned senior civil judge Khalikot. In course of hearing, it is submitted that it is submitted by a counsel appearing for both parties that their respective clients are presently working in Bangalore.
My client is not working. My client is not working at Bangalore. She is no more in job.
Private India
that you are presently what I am saying I am presently.
Acha how?
Layoff ଆପଣ ଜାଣିଛନ୍ତି every day.
So I will on concern this order should I pass? Without going into the facts.
Your lordship may say looking at the contents or hearing at the contention of the parties it is directed. Consent at times may causes inconvenience.
Several grounds have been cited by both parties justifying their prayer for transfer of the cases. Stop. After considering the after perusing the transfer applications and on consideration of the submissions made, this court is of the considered view that ends of justice would be better served and it would be convenient to both parties if the proceedings in question are held before the appropriate court at Khurda. Stop. In such view of the matter, both the transfer applications are disposed of with the following directions. A proceeding of such and such is transferred to Khurda. The proceeding of such and such is transferred to. Yes. Say order. Say order. Say देखिए लिखिए.
Will it be convenient or parties will appear a particular dates because both station must be notified.
He will issue notice. After the receipt of records, he will issue notice. Yes.
Item 38.
I am for the opposite party.
38.
See, present petitioner, being the wife, filed a transfer petition that the divorce proceeding filed by the husband transfer from the civil judge advocate to judge family court. And petitioner was
No chance of settlement?
no,
No chance of settlement?
no, ma'am.
Then yes, what is your contention?
That may be transferred to Cuttack. I have no objection. But there is a mistake in, I am taking this notice from police. CP number 108 of 2022. That is MAT case number 15 of 2020.
ये election CP 108 of 2022?
I'm not.
नहीं, ताको transfer application is election थी. भीतर election की तो MAT 15. You correct your cause title.
Well,
I will equivalent counsel with the petition is permitted to correct the typographic in court. ये तो कोर्ट है बता? In court. तब transfer application allow कर दो. Yes.
okay.
Item 39.
39 Lordship, date is mediation date is fixed to 31st of August as the last chance. So
It
let
is
it
submitted that the next date of mediation is fixed to 31st of August. Hence is this matter
11 September.
on 11th September.
interim order to continue.
Which in order to continue.
Item 40, in the last occasion, it was, the notice was served to IAC.
Yes.
Yes. What the information matter that the opposite party has received that communication on 31/7/2024. Yes.
When State Council informs that the opposite party has received the notice on 31/7/2024. There is however no appearance. Please this matter next week.
Obligement.
Item 41. May I please announce it?
Last occasion, your lordship has called for extension from Milan Civil Judge Navarampur. Because of appeal was admitted, second appeal was admitted, and the ignition case was stayed till dismissal of the appeal.
Asian resurfacing पके दीजिए तो ये मैं कोनो तो Asian resurfacing रा केस पके किसे करचन तो as directed learned civil judge Navarampur has submitted an explanation as to how she could proceed with the execution case despite order of stay being granted by this court. Stop. It is stated that the proceeding was originally stayed, but as per order, as per the ratio laid down in the case of Asian resurfacing of road agency, so and so of the Supreme Court, the stay was vacated within the knowledge of the party without any objection. Stop. Further, the learned civil judge joined on 18/7/2022 and proceeded with the execution case without noticing the order dated 13/8/2021 of her predecessor vacating the order of stay, applying the ratio of Asian resurfacing supra. Stop. However, after receiving the order dated 28/2024 of this court, the further proceedings in the execution case have been stayed. This court observes the subsequent order, Asian resurfacing. Asian resurfacing the subsequent order. This court observes that the original order passed by the original order passed in the Asian resurfacing has since been shall we say modified, has since been modified by a larger bench. Yeah?
Not modified, it was not good. Last paragraph.
Was held to be bad law.
My lord.
Very.
Overruled, isn't it?
Overruled.
Overruled.
Very well.
But they have not said so. See, they have said that we are unable to concur with the directions in paragraph so and so of the Asian resurfacing.
My lord.
Accordingly, the ratio. This has since been overruled, and and it has been clarified that we clarified that. This is broken. Hello. The reference may be had to the said order of this of the larger bench. Past case of High Court Bar Association Allahabad versus State of UP and others. 2024. 1 OLR. Director SC 775. Stop. Obviously, the learned civil judge was not alive to the change of law.
My lord, I filed a petition for recall of that 85 order, that was rejected.
That is a clear case of contempt.
I have stated in my petition, my lord.
Acha ho, pardon. Though the change of law was intimated specifically through a petition to the court below. You are the plaintiff or the defendant? You are the judgment debtor.
I am the judgment debtor.
By the judgment debtor. That petition was apparently rejected. This court expresses serious displeasure over such conduct of the court below and cautions the presiding officer to be more vigilant in future. Stop. However, as the court below, after receiving the order passed by this court on 28/2024, has already stayed the execution proceeding, as also taking note of the fact that the officer concerned is young and inexperienced. This court, taking a sympathetic view, accepts the explanation submitted by the court below. That's all.
Your lordship wanted to know how the state is concerned in this suit. In fact, state has been implicated as defendant number 2 to 4 because there was a Indira Awas construction made over some portion.
So we'll hear this matter when? Today or admit each? Admit each. When shall we hear it? Where are you ready? 2011 matter, we can hear it anytime.
2017 matter.
2017? Oh, 2017, ঠিক আছে। 6 বছর আগে। কেবে? Next week হবে না, তারপর week হবে। Let's just appeal for hearing in the week commencing 23rd September.
Item 42.
Pass over.
Item 43.
Madam, I'm an appellant, pass over only.
Pass over. He's asking for pass over. Pass over.
Item 44.
Item 43 ରେ ସେ ଗୋଟେ miscase file କରିଛନ୍ତି 848 of 2024. They have not served copy of that miscase. My lord, I was absent, my lord, last time, my lord, I was, my lord, outside. ଗୋଟେ ଦେଇନାହାନ୍ତି ଏଇଟା ଗୋଟେ objection ଟା କାହିଁ file କରିବି? My lord, my instruction, my lord, now the referral court, my lord, the hearing is going on. My learned friend, my lord, filed IA, my lord, submitting that the has been passed and.
No, I'm not probably, our is not, my prayer is stay further proceeding. Honorable court passed order, not my prayer, my respectable submissions, the respondent claim, the civil judgment.
I have said that he has submitted that the LA case in question is about to be finalized. And the compensation amount is likely to be disbursed in the near future. This was his submission. I only said that stay further proceeding. I only said that the compensation amount determined in the LA reference case shall not be disbursed. They are not affected anyway. You may file an objection if you want to. But let us hear the appeal. What is that? Let us hear the appeal.
My resolution, the respondent claim compensation as per civil court judgment.
Well, I will not
Civil court judgment challenge before the appeal and after.
You say, both of you tell me a date, I will fix the appeal for it has been admitted.
Admitted, my lord.
So LCR is available?
Yes.
LCR is available.
Then
notice भी पाइଛନ୍ତି appear भी କରିଛନ୍ତି.
My lord, I have gone through your lordship's order. My lord, my impression, my learned friend, the referral court already passed.
To stay further proceeding of LA reference statement charged by author.
Miscase, my lord.
All right. My lord, এটা modify disbursement টা কটিକିରି my prayer to stay further proceeding of LA case number charged by author. এটা automatic.
କଣ ଲାଭ କଣ? ତ କରି ଲାଭ କଣ? ଯାହା ଦେଇ So, as requested by both parties, this is matter for hearing in the week commencing
30th September.
30th September.
My lord.
Further proceeding be stayed by
continue.
Continue, my lord. সেটা ইমপ্লিমেন্ট টা মই লাগিଥିଲେ stay further proceeding automatically কথা ଗୋଟେ judgment এটি চ্যালেঞ্জ হচ্ছে
Subject matter of the suit.
I know. Why I have passed that?
This is not why not subject matter, my lord, running base.
This is the.
I will not modify that order.
No, my lord. Interim continue, my lord.
ବୁଝୁନାହାନ୍ତି ଆଜ୍ଞା ଆପଣଙ୍କ କଥା ଯୋଉଟା ମୁଁ କଣ ନଚିନ୍ତା କରି ଅର୍ଡରଟା ପାସ୍ କରିଛି?
ନାଇଁ, my lord.
ସଡଙ୍ଗି
Copy shop interim continue.
Yes. Item 44 କଣ ଲେଟର ଆସିଛି ଏକ୍ସଟେନସନ ପାଇଁ? Six months further time is 4 months further is allowed to the trial court to dispose of the case.
Item 45.
May I please, Lordship? The case of 20B of NDPS Act, Lordship, where the petition in the custody says 22/8/2023.
Subhendu Vishwas.
4 kg of ganja for transportation, and they were utilizing 2 vehicles, and the 4 persons were involved in the crimes.
Outsider.
Outsider. Lordship also considered the one of the outsider. I was standing in similar footing, Lordship. The outsider who is also on bail, he is also cooperate with the learned trial court, Lordship, by appearing on the dead.
Rahul Mishra.
Same order টা দুইটা কপি দিয়েছেন।
Lordship.
Same order ର দুইটা কপি ଦେଇଛନ୍ତି দেখো।
ନାଇଁ ସେ ଗୋଟେ ହେଉଛି ଯୋଉଟା ଟେକ୍ ହେଇକି ଆସିଲା ସେଇଟା କମନ ଅର୍ଡର ପାସ୍ ହେଇ BLPL ନମ୍ବର 10648
ନାଇଁ ନାଇଁ ଆପଣ ମତେ ଯୋଉ ଦେଇଛନ୍ତି ଏଇଟା ଦିଟାଙ୍କ ଗୋଟେ କପିର ଦିଟା ଜେରକ୍ସ କରିକି ଦେଇଛନ୍ତି।
ନାଇଁ ଗୋଟିଏ ଅର୍ଡର ଆରଟା ଟେକ୍ ହେଇକି ଅଛି
ଦିଟା ସେଟ୍ ଦେଇ ଦେଇଛନ୍ତି।
That was prior to submission of charge sheet.
Charge sheet submitted, Lordship. Final PR has been submitted in the meantime.
Yes, what is his
My lord, he has not supplied anything except the rejection order, so it is difficult to
case diary on
whether
Case
he is
diary
on
be
similar
obtained?
footing or not. And
Case
he
diary be
looked
obtained,
only
list
the
this matter
evidence.
on.
This case was also present near the other car. at
We'll
the
see,
time
we'll
of
see,
the-
we'll see what can be done. His interim bail can be granted, keeping the main application pending.
Yes.
List this matter kebe?
18 September.
On 18 September. Case diary be obtained, will you please?
Item 46.
46 for extension of time. Your lordship was pleased to grant me 2 months time on 2/7/2024. And it is expired on 4/9. My lord, on the ground of the ill health condition of his infant daughter, who is suffering from bronchitis, I have
Interim bail granted by order dated 2/7/2024 is extended by further period of
2 months.
No, 1 month, 2 months ହେଇଥିଲା ଆଉ ନା?
Oh,
Yes.
ठीक है.
Item 47.
May I please, your lordship? My lord, petition is in custody since 25/1/2022, my lord. For the offense under section 21C, 29 of NDPS Act, read with 25 and 27 of arms act, my lord. Here in this case, my lord, out of 18 witnesses, 6 witnesses have been examined. There, my lord, some interim bail may be granted from that.
Brown
1 kg.
Brown sugar.
More than 1 kg.
Having no antecedent, local man, gotte mas hobo chhe.
Brown sugar ହବନି।
Local man.
No, no.
More
No.
than 2 years in custody,
No.
my lord. 22/1/2000,
No, no, brown sugar ହବନି ତ କହିଲେ।
any condition में थाना रे appear.
The petitioner is in custody in connection with such and such case. I'll not grant it, I'll reject your application.
Next week, my lord.
What next week? Is this matter 1 week after?
Item 48.
That's over.
Item 49.
Earlier, your lordship has passed an order. This is a case wherein from this spot, 139.950 grams of ganja was seized. The FIR stated that 40-50 लोग से जंगल ले जाउथिले एमान देखिले पुलिस पहुंचला परे पळेले बाकी 8-10 जन से डिटेन कला नॉट फ्रॉम द पोजीशन आ तापरे से तो आस्टन से गां लोक आसी पुणी आकु नै आइछन सो 48 सेक्शन 43 एनडीपीएस एक्ट से माने अरेस्ट करि पारलेन तापर सब्सिक्वेंटली आ गोटे एफआईआर हला मास्कुंटे एमान जाई गां लोक घेरो कले गां लोक सब आथिले तापर एमान को सब्सिक्वेंटली एमान को अरेस्ट करचंती अरेस्ट कला पर मास्कुंट के हाई कोर्ट बेल देला तापर आपण पाखरे पहुंचला सेतळकु 2 वर्ष पाखा भाई 2 वर्ष रहि गलानी से माने इन कस्टडी द लॉर्डशिप ग्रांटेड 3 months interim bail after completion of 3 before completion of 3 months they have surrendered thereafter they made the bail application that was rejected so they have come for the second time.
You have the case diary?
No, my lord, case diary is not. First time it has come.
You got the case diary, then we'll see.
Charge sheets are
Case diary be obtained, list this matter in the week, kebe?
18 September.
On 18 September. Yes.
Item 50.
Here in this case, my lord, directed file IA in APL appeal number 7786 of 23. That has not come, my lord.
You will come tomorrow along with
tomorrow. 7786 of 23.
List this matter tomorrow along with
file करछि पूरा
along with ABL appeal number
7786 of 23.
7786 of 2023 tomorrow.
Item 51.
May I please, your lordship? By here in this case, my lord, both were love with each other. In the meantime, they have got married.
376.
Yes, yes. 3 they the principal accused. No, खाली मु कहूँ जे compromise हेला से माने ये
एकाट रोचंदी बाहाई की and girl has come and your lordship director surrender go on bail. I'll file a quashing application.
373, 376, 3 anticipatory bail na mo direction debi.
Your lordship granted bail to the other co-accused person, family members are concerned. That connected record has come.
Sithile,
Aye.
I have taken note of the allegation that the allegation of sexual
Eकाट रोचंदी 18 plus. That's why both ये girl has come, my lord.
Why did you bring the girl? Why did you bring the girl?
नहीं मु and she कहला
No, you should have stopped her.
आगे.
You should have stopped.
Counsel is appearing, my lord.
This becomes very embarrassing for the court. And but I cannot entertain this application. Okay.
No coercive action देता है देखो जी मुझको.
No, hold.
Let them CD may be produced, my lord.
313 is there.
He'll file a application.
No, wrong violate could be. 376, 3.
CD may be with 164 statement.
438, 4 is a bar, direct bar. The application is not consider it, Mr. Sahu. With your vast experience, how can you say so? And these are the orders which I was passing when I was hearing bill, anticipatory bill applications. In many of your applications also, I may have passed it.
In this case, my lord, both are got married and they are staying together.
No, that will not
That's why
that will not improve the situation.
482 is there.
He grant some interim protection. Lordship keep it to 1 week after, my lord.
But without any interim protection.
Interim टा दरकार है यहाँ.
जोटा maintainable हुए, मु तनको interim protection करेंगे.
नहीं मु कोई ना दंदी. जेहेतु बाहाई के एकाट
कोई न था किंतु कोई जला नहीं. How many?
Keep it to 1 week after.
1 week after. That's great for.
Item 52.
Order be corrected accordingly. है ना? ये correction तो करें तो पासवर्ड तक ये 10 मिनट जितनी का है वो पासवर्ड रखिए.
So item number 7.
Wife's application for transfer.
The fresh matter
Again.
from
The wife is working at Korapur.
from which place to which place?
My lord, mat case pending below civil judge senior division Satrapur to family court Jaipur.
All right, take notice. Notice stay. Yes.
23rd October.
23rd October.
Item number 8.
Present application for transfer the instance of the wife. The husband filed an application on 13-1 before the Lion family just Cuttack. But
What have you won, sir?
Lordship, what happened? Initially, the husband has filed the divorce application within the 1 year of marriage, and filed an application 14 to paying for leave to file the same. That was pending. But facts remain. After completion of 1 year, the present petitioner wife also filed an application before the Lion family judge Bhubaneswar for divorce. Your Lordship. My respect submission, the present petitioner also filed an DB application before the Lion SDCM Bhubaneswar that was pending, and the Lion present opposite party husband has already entered appearance before the in the DB matter. Your Lordship. And that here the application filed by the opposite party husband, the divorce has not yet been admitted, but rather that is pending for whether the matter is maintainable or not. That application is filed and intentionally not to harass the present petitioner wife. I respect something that matter may kindly be transferred.
Cuttack won, sir.
What happened? I am not disputing the Cuttack bonus. There is no reference.
Yeah, why will you dispute? Dispute
But that application is filed within 1 year of marriage.
Sir, how is it that will not be considered by this court? That on merits, I will not consider.
And the wife already filed an application for divorce before the Lion family judge Bhubaneswar also. In that matter, notice has been issued. But the present opposite party husband not yet appeared in the before the Lion family judge Bhubaneswar also. My family just cut off within the under marriage and filed an application 14.
No. Cuttack won, sir.
That's my predicament is there is two applications. One is under the DV Act, 12 of the DV Act, and another is for 13. The instance of present person wife. That was pending before the family in Bhubaneswar. If you present CP can be
notice.
Item 9, stay of the further proceedings.
What's that? So, item 9.
May I please, your lordship? The petitioner before your lordship challenging the appointment of a cadre officer followed by the notification dated 9th April 2010 and 31st December 2014. The fact before your lordship, a cadre officer holding two cadre posts simultaneously, being the head of the Parliamentary Affairs Department and also.
Why has this come to me?
It is the rate in nature of co-warrant.
Honorable Chief Justice, sir.
What is your prayer?
Here, my lord, the petitioner is a stranger, he is a citizen of India. The rate of querent says that any citizen, any stranger can file an application under Article 226, invoking the rate jurisdiction to prevent a person who has usurped a public post not entitled to hold that post. Law says that.
No, what is your grievance here?
Grievance before your lordship, the person who is usurping two cadre posts simultaneously, violating the Rule 11 of the Indian Administrative Service Rules 1954, unauthorizedly, he should be ousted from that department, followed by the appointment. There's the Rule 11 of the Indian Administrative Service Rules 1954, wherein it says that law said that the appointment is contraventions to the statutory provisions. Law says that Rule 11 says that Indian Administrative Cadre Rules 1944, Rule 11, the state government concerned in respect of the
No, sir, please answer me. What is your grievance? How are you aggrieved? What is your grievance? I must consider that.
Petitioner has no personal interest or independent interest.
So file a PIL.
No, in service matter, PIL is not maintainable.
Then there's no remedy individually unless you have a individual grievance. This cannot be considered.
Rate of querent says that. Precedent under Article 141.
No.
My lord, I may be permitted to place one sentence. It is decided in Rajesh Awasthi versus Nandlal Jaiswal, year 2013, SC 78. The procedure of querent confers jurisdiction and authority on the judiciary for executive action in the matter of making appointments to public offices against the relevant statutory provisions. The Honorable Supreme Court has opined that a citizen can claim a writ of querent and he stands in the position of a relator. He need not have any special interest or personal interest. The real test is to see whether the person holding the office is authorized to hold the same as per law. It is decided in the case of Rajesh Awasthi and Nandlal Jaiswal. And another precedent is year 2001, Bahadurnath versus State of Rajasthan. A party cannot be permitted to advance an argument if it has obtained an order of office in clear violation of statutory provisions. His action is alleged to be against the public policy or to have been obtained by misrepresentation, collusion, or fraud, because the action shall be void ab initio.
And I think it has also become infructuous in the meantime.
No,
he is no longer the
petitioner challenge the appointment followed by notification. Notification is ab initio void, my lord.
So. Now this opposite party number 3,
my lord,
whom you say that he has been holding two posts simultaneously, including the post of Principal Secretary to the Housing and Urban Development Department, is no longer the Principal Secretary.
Before that, this writ petition was filed before the Honorable Court.
Before that, but the notification was issued maybe 10 years before.
Deal and laches will not bar the filing.
No. Deal and laches, it is the discretion of the court. It's not that easy.
No, my lord. It is held in the category of judgments. It is the year 1954 in the case of Kasinath, Lakshman, Bhide and others versus State of Bombay. The Honorable Supreme Court.
You satisfy the court Why? He was appointed maybe in 2010 or some.
Yes, my lord.
So why are you coming to the court in 2024?
Yes, my lord. For your lordship, I am only presenting a fact, only presenting a submission, my lord. It is held in the Central Electricity Supply Utility of Odisha and Dhobei Sahu and others. Year 2014 Supreme Court 246.
Yes, what do you say, Mr.
The principle of doctrine of delay and
For the
laches.
first time.
Huh?
Coming for the.
How is it maintainable? You satisfy the court on maintainability. How is it maintainable?
My lord, delay and laches should not be allowed any play because the person holds the public as an user for.
Yes.
And such continuance is to be prevented by the court.
Yes. Without reading the entire facts, you are saying this. So the question of applying this delay, the concept of limitation will be taken away.
No. Every day the cause of action arose. Every day, as because the person who is holding the office unauthoritatively violating the statutory provisions coming under Rule 11 of the Indian Administrative Service Rules. In each and every day, cause of action arose. In each and every day. So there is no delay and laches.
And how are you aggrieved? Simply by saying that in a writ of quo you need not show your.
No, my lord. It is decided in the scatter.
What judge decided, sir? How you? The court wants to know. You have to answer the court.
Yes, my lord.
In spite of those decisions which you have cited, I may have no quarrel with those decisions, but you have to satisfy the court. Who are you? What is your locus standi? What is your grievance? If that person continues as principal secretary for 10 years, 15 years, for whatever. Who are you? What is your identity first? Let us see. How have you described yourself? Accepting that you are a citizen of India. We all are citizens of India.
Yes, my lord. Provision of writ of quorum says that.
Sir, please don't go to the law. I am asking you. Who are you, sir? Who are you? I mean, what is your identity?
I am a relator. I am a stranger of who has filed this case. I am stranger. Simple. I am a stranger.
So you are not aggrieved.
No, it is not required. The person who has.
I don't know whether it is required or not. It will be decided by the court. Are you aggrieved? Are you in any way, any manner aggrieved by that person?
As because a person who is not entitled to hold that post, being post since 2010, a citizen can file a case before the Honorable Writ Court, invoking the jurisdiction to prevent that person and ousted that person.
You have said that. You have already said that. Please don't repeat. You have already said that.
Sir, yes, my lord.
So.
It is a provision of law.
I am not prima facie satisfied, but if you want to cite some judgments, you can. You satisfy the court on the maintainability aspect. I am closing it. You file a note.
I am submitting the citation, sir.
Hearing concluded on the question of maintainability of the writ application. Heard Sri Swanso, and Sri Ardas Learned State Council. Hearing concluded on the question of maintainability. Yes. You have given a note.
Notes of submission. I am simple file the citation, sir.
If you want to file a note, you may
file.
Counsel with the petitioner.
File the notes.
Counsel with the petitioner commits that he would file a note of submissions by tomorrow. Yes. Okay.
Correction.
Order has been passed.
Let's say item 26 pass over, let's say that don't next to the
13.
Lordship, item number 48.
Wait for time because item number 2, court number 17, bail matter. Lordship may keep it to next.
Which bill? Item number 2?
Court number 17, I have a matter, item number 2.
Item number 2 কোন বর্তমান দিন দিন
না 7 এ যাইছি 2 মোর নাও
which bill?
7 নম্বর পর্যন্ত যাইছন্তি মোর আইটেম 9 সো আইটেম 2
ওহ সেই দৃশ্য হাতে যায় মাত্র সরি
court number 17 after this just before recess
all right please so you when do you want
next week your lordship may
all right is this matter next week as well
Item number 14.
Lordship, item number 48. Lordships, item number 48, praying for 7 days time.
I think notice on opposite party number 3 is not sufficient as yet. State project director or OPEP, I think you can appeal.
They're appearing.
You can appeal.
They have submitted that they will appear.
All right.
But till date, my lord, we have not received any information. On the last occasion, my lord, the petitioner filed a rejoinder, my lord.
Yes.
And to that extent also, my lord, we have intimate critics.
On the last occasion, actually, he said that petitioner number 1 had died, so his name was deleted.
Yes, yes.
Yes. Then
Now, a copy of the rejoinder we have received, my lord. This matter will be taken up in the second week of September, so that.
Rejoinder, I have not. This is a formal rejoinder.
On the basis
I have
of the
not
available
stated
material
anything.
record also, my lord, I am prepared.
Only on the issue.
I leave it to
small
you.
issue.
I leave it to you.
Right.
I leave it to both of you. If you want time, I can grant time, but you want up to you. I have to hear the matter.
ଗୋଟେ ଚାହିଁଦିଆ ଯାଉ କାହିଁକି ନା ସେ ଓଷେପାର ମଧ୍ୟ ଇଏଟା ଭିତରେ
Will the order of the collector. My challenge is that କହିଥିଲେ ଆରଥର ମୁଁ ପାଠ ଆଡିକି କରିଦେଇଥିଲି. Advertisement, selection, everything was in the school and mass education department. There was no whisper in the government resolution that yes, if you are selected by the school, you will be deported or you will be posted in the SC/ST development department. They
So that matter, yes, I remember.
SC/ST development department, they have their own rule for recruitment.
I remember.
What happened? There the select list was published by them. They say we have some vacancy, send somebody to us. This is their internal communications. In the first phase of selection, these petitioners they could not make. But there was second, third, fourth phase of selection. After the first selection, they direct us to join there in the because the collector is the authority here also and there also. SC/ST development collector is also the chairman. Here he is the CEO, chief executive officer. So this is the position. So they have gone in. So in the right from the day one, we have objected that yes, because we have selected for the school and mass education department, we should be allowed to continue. But in the second and third phase persons, those who have come, those are merit junior to us in the merit position, allocated to the school and mass. So this is the how we want that we should be repeated to the school and mass education department because what they are now saying in the counter as well as in the impugn order itself, because this is a second round litigation. They are saying you have signed an agreement and volunteer to go there. That is why you cannot go back. My responsible submission to this is not the law. There cannot be an estoppel against the statute. When the statute provides that the selection is to be for the school and mass education department, you cannot bring some person and put in the different department.
All right, I'll say
That is
that.
the only point. That is.
If he may otherwise be misunderstood, so I'll just grant him one more time.
Yes.
For further arguments and part, let this matter, but no further adjournment.
Well, today also I am prepared. Only thing because there is a technicality, my lord, on the last occasion, the lordship directed instructed me that to get the instruction, if any, from OSHEPA. So that is why, my lord, we have written the letter, but we have not received any response. That is why.
All right, all right. So, any for further arguments and part. Sri S.N. Patnaik, Learned AGA, submits that he has sought for instructions from OSHEPA, but has not received the same as yet. He requests for some time to obtain the instructions. Stop. Since this is a case of the year 2016 and has already been heard in part, last chance is granted to the state to obtain the instructions, telling which the matter shall be disposed of on the basis of available pleadings. Is this matter on
11th September.
11th September. No further time.
So right now 19.
None appears, disposed of. Amar kota order hobe. Hala, do not appear. If any cause of action survives, yes.
So right now 20.
20, same order, disposed of.
So right now 26.
Taken over lordship next week, Mr.
May I pray for Friday, one was appearing in this case.
Yes.
And as per his availability.
Friday. All right. Place this matter on Friday as requested, as prayed for.
Always. Friday.
Sir, coming Friday. Any other than Friday?
Tomorrow.
No, tomorrow I have no. Friday I will be on leave.
Tomorrow. Place this matter tomorrow.
Always.
So right now 29.
Item 29 on behalf of Mr. Senapati, he is not well. May I pray for some other day?
All right. You would get it.
Next week.
All right. Leave this matter next week as prayed for.
There is an interim order.
Interim order to continue.
Obliged.
So right now 42.
May I please? Not, this is a modification of order, my lord. The para 2 order dated 8/8/2024. It is inadvertently within 18 years.
Sir, 8/8/2024.
My lord.
Order dated 8/8/2024.
My lord.
देखिए फाइल देख लो इसमें नहीं
8/8/24. Lordship
Para
granted
two
4 months
90.
interim base.
No, earlier order was on 17/5.
17/5. Thereafter 8/8. 17/5 interim order extended for a period of 1 month. But on 8/8, your lordship granted 4 months. That's been typed 8 months custody जगह 18 months like that. 8 years. 8 years जगह. 18 years.
अच्छी 8/8
Order टा दो ना दी order टा.
मिले स्कैन कहीं 18 years से 8 years होगा
My lord.
yes the word 18 occurring in third line of paragraph 2 be corrected as 8 तापर
Paragraph 4, second page, my lord. Fourth line, my lord. My lord, the
3 months
after expiry of the after certain period of 3 months.
further the word 3 occurring in paragraph 4 be corrected as 4 FOUR है ना sir that's it
I don't know 48.
My lordship, praying for 15 days time.
48
Praying for 15 days time. I've already filed the IA. Praying for 15 days time. My lordship. My lordship. My lordship. Praying for 15 days time.
yeah
Already filed the IA. Yesterday I have filed the IA.
Asim na
Copy has not been.
do you have the number of the IA
No, sir, I have not got it.
all right Lieutenant Counsel to the petitioner submits that she has filed an IA the same is not on record list this matter tomorrow along with the IA
A copy may be served.
further a copy of the IA be served upon the State Council ensure that the copy is served on the State Council
Okay.
yes it will come tomorrow hello yes weekly list That's what actually लगे थे नहीं hearing होगा
I don't know, quickly list, I don't know, 37.
Item 18 was passed over. Yes.
So what about it? Let us continue with the list. Then. Yes. Item 37.
Yes, good for specific performance contract.
Yes.
Appellant is the main plaintiff, my lord.
Reversing or confirming? Reversing judgment, yes.
My suit is allowed. Suit is allowed. Ground of challenge, you file the civil suit, we should bias point. The plaintiff is the wife of the husband, wife of the husband, my lord. He has one agreement was held to purchase the land from the respondent. There is a valid agreement, my lord. Yeah. That was accepted by the trial court, my lord. Directed to subsequently after the agreement, they have sold the land to others, my lord.
You executed an agreement.
Executed agreement.
Agreement for sale.
Sale. Respondent executed an agreement for sale.
The defendant executed an agreement for sale with you.
With me.
Yes.
To sell the land and taken the advance.
Yes. Then,
my lord. Thereafter, it is a registered agreement.
Yes.
They have sold the land to the respondent number 3, 4, and 3, 4 subsequently sold the land to the 5.
So you filed a suit. Suit was decreed.
Suit was decreed. Allowed to execute the sale deed in favor of me.
Okay. Decreed in part against contestant against defendant number 1, 2, and 5 and expected without declare the resident agreement. Registered agreement number 8. And the 20% valid agreement which is usually enforceable. All right, then the defendant filed appeal.
The file appeal, my lord.
Yes.
Appeal was allowed and filed by them was allowed. On the ground, there are some discrepancy. Only on this ground, the appeal is.
What was the discrepancy according to the first appellate court?
From the land numbers, my lord, some discrepancy. On that ground, they allowed the appeal.
Whether the lower appellate court lost sight of the provisions of section 10 of the Specific Relief Act while refusing to grant the relief for the specific relief act. Specific Relief Act. So this is the ground.
This is the ground.
It has been admitted on the only substantial question of law is that section 10 of the Specific Relief
Act. Section 10. Provisions of section 10 of the Specific.
May I submit 2 words, my lord? Actually, it is a performance of contract. Agreement was executed by defendant number 1.
In favor of the plaintiff.
Original landowner was Notabara. Notabara died leaving behind Narahari and daughter and the widow. Narahari, the son, he executed the agreement with the plaintiff, man. And agreement was for 1 year. Within 1 year, they are to pay the balance consideration money, get the executor. Within that 1 year, out of 10,000 consideration money, they have paid only 1,500. 1 year, they didn't do anything. After 1 year, this 1 year was over. Again, another 1 year, 2 months, they didn't do anything. Defendant number 1 and defendant number 3, the mother, son and mother sold some property to defendant number 4. And the defendant number 4 sold it to defendant number 5. Now, my lord, they have filed the suit for specific performance of contract by stating the area and description of the land agreement and the sale deed in which we have taken I have purchased this land is something different. This trial court said that description may be different, but that is the land. Appellate court said no. Description is something different. So this land is not equal to that agreement land. Secondly, defendant number 1 is not the Karta. This appeal has been dismissed as against respondent number 4, that is defendant number 4. If appeal has been dismissed, that first purchaser to which defendant 1 and 3 have sold, if appeal is dismissed, the appellate order is confirmed as against that defendant number 4. And defendant number 4 sold it to defendant, that also is confirmed. Then what relief they will get? Whether the suit appeal will continue Only thing that they will get back their money, 1,500, which has been decreased by.
They are avoiding to take the balance amount, my lord.
No, not balance amount. This amount which you have
In spite
advanced.
of my request, they sold the land. I was persuaded many times to execute the document, my lord.
No.
They were avoided and
Your lordship has
subsequently
seen the finding of the appellate court at page 14. But as the case that may be, my lord. But now whether the appeal will continue, once the appeal has been dismissed, as against respondent number 4,
For not taking of steps for as long as 19 years.
Yes, my lord.
That is why I dismissed that appeal.
Yes, man. So they have not taken steps. So whatever may be, then now the appeal has been dismissed. That fact is admitted by them. That is not been disputed. Then appeal has gone. Is the decree separable? Decree is not separable. So once the appeal is dismissed as against defendant number 4 or respondent number 4, the entire appeal should go.
Yes, Mr. Mahathi. It's up to you. If you would like to continue with this appeal. Because you are not going to get any relief out of.
That is a valid document.
That is all right. That is on merits. That is on merit. But it has to be converted to an enforceable decree.
Other co-partner and shares, they are not challenged the agreement, my lord.
But how can you say that I have not challenged other co-partners? Defendant number 3.
You take instructions from your client in this regard. Since the respondent number 4, the appeal has been dismissed, and he is the first purchaser. From him, the other defendants may have purchased the land, but he is the first purchaser. From defendant number 2, after executing the agreement, has sold it to.
Instruction to sell the land to others. Suppress kala bhi seta ase.
Seta apna koi period. Kana thala apna karo sei ground ta that argument will be
not challenged.
Mr. Mahathi, that argument will be counterproductive because then his competence to execute such a contract with you can also be questioned on that ground. He not being the karta, he could not have executed such a agreement. So that argument will be counterproductive. Anyway, part in part, let's just matter next week. We'll come next week for whatever you take instruction, thereafter we'll dispose of.
1 week after.
We commencing?
2nd September.
We commencing 2nd September.
2nd
September. The week commencing. It will come in the weekly. But it will come at top of the list because it's a part-hard matter.
Part-hard matter?
Yes.
Item 39.
Place of Passover, item 39. And for the appellant.
Passover may be for the day, madam.
Passover for the day.
Item of 40.
Supervisor.
Please, your lordship. Defendant is the appellant against reversing judgment and decree.
Yes.
The plaintiff filed suit for declaration of right title interest and confirmation of possession. The plaintiff's case is, before going to the fact of the case, I may take your lordship's attention to the genealogy.
Yes.
Genealogy I have extracted in the appeal memo at page 2. The original owner of the suit property is one Hora Karno.
Yes.
Wife of Devara Karno. Hora Karno had 3 daughters, Padma Mandili, Golapi Danta, and Kadami Mahakur. Well, this Kadami Mahakur died issueless.
Yes.
After death of Hora Karno, Padma Mandili and Golapi Danta, these 2 daughters made an amicable partition among themselves, and the suit land was allotted to the share of Padma Mandili. So far as Golapi Tanta is concerned, some other property of Hora Karno was allotted to her share. 2 mutation cases were filed in the year 91 before the concerned concerned Tahsildar, and accordingly order was passed, and the suit land was allotted very much to the share of the present appellant. But while the matter stood thus, the plaintiff, Golapi Danta,
filed a suit claiming that after death of Padma Mandali and Golapi Janta, Bhumi Mahakur, daughter of Golapi Janta, filed a suit claiming that after Padma Mandali and Golapi Janta, she being the only legal heir, she is entitled to the entire share of property of Padma Mandali.
Disregarding the previous partition.
Disregarding the previous partition, my lord. Thereafter, my lord, the pleasant defendant entered appearance and filed a written statement along with a counterclaim.
You are Padma Mandali.
I am daughter of Padma Mandali.
I mean,
Foster daughter of Padma
Yes.
Mandali. I entered appearance and filed my written statement along with a counterclaim. In the counterclaim, I specifically declared, I made a prayer for declaration of right title interest, confirmation of possession, and in the alternative recovery of possession. My specific case was that there was a mutation between, there was a partition between Padma Mandali and Golapi Janta in respect of the suitable property, and it was allotted to the share of Padma Mandali, and the present defendant was the foster daughter of Padma Mandali. She was the husband's younger brother's daughter of Padma Mandali. So what happened, my lord? She was taking care of Padma Mandali and her husband. So, as being satisfied with her service, they executed a registered sale deed, executed a registered will nama in favor of the present appellant, my lord. And by virtue of that will nama, which was duly registered, by virtue of that will nama, the land in question was recorded in the name of the present appellant. My lord, the London trial court, my lord, framing as many as 10 issues. Issue number recorded is finding. So far as issues are concerned, my lord, issue number 4 and 5 is important. I may take your lordship's attention to the judgment of the lower court, my lord.
Yes.
Issue number at page 9, your lordship may talk to. Issue number 4 and 5. Lordship what?
Yes.
The issue number 4 aims at determining as to whether the suit land is joint family property. The issue number 5 aims at determining as to whether there was any previous partition between Padma and Golapi, and the same is binding on the plaintiff. Both the issues are taken up together for discussion, as they can be answered with common discussion of evidence. First of all, I am inclined to indicate that the suit land refers to the land with an area of acre 2.564 decimal under Sabik Khata number 69 of village Toboda, recorded in the name of Padma Mandali. And the same corresponds to Hal Khata number 32 of village Toboda, stands in the name of Bhagyavati Mandali with an area of acre 2.64 decimal. In Sabik settlement, it was exclusively recorded in the name of Padma Mandali, and in the Hal settlement, it was recorded in the name of Bhagyavati Mandali. Now it is to be examined whether such recording of suit land in the name of Padmavati Mandali in the Sabik settlement and the name of Bhagyavati Mandali in the Hal ROR is correct or not. To examine this point, it is felt that Exhibit G and H, those two orders of the mutation authority, Tahsildar, Exhibit G and H are most important documents to be referred to. Exhibit G is the certified copy of the entire order sheet in miscase number 166/90, and Exhibit H is the certified copy of the entire sheet in miscase number 594 of 90. When miscase number 166/90 has been filed by Golapi Janta, miscase number 594/90 has been filed by Padma Mandali before Tahsildar. Both the cases have been disposed of by Tahsildar Contamal on one day, that is 26/2/91. As per the order sheet of the above mutation cases, there was a mutual partition between Padma and Golapi after the death of Hon'Ble, and on the basis of the mutual partition, the lands under Khata number 68 fell to the share of Golapi Janta, and the land under Khata number 69 fell to the share of Padma Mandali. Based on amicable partition among the two sisters, both the miscase number 594 of 90 and 166/90 were disposed of by Tahsildar Contamal, and Pata was issued in favor of Padma and Golapi for Khata number 69 and 68 respectively. The order sheet maintained by London Tahsildar Contamal in miscase number 594/90 and miscase number 166/90 sufficiently speaks about the mutual partition between Padma and Golapi, and I am inclined to believe the same. In view of such partition, Exhibit B was issued in favor of Padma Mandali and Exhibit D was issued in favor of Golabidanta. This is potash, my lord. Which relates to lands under Khata number 68, out of which Golabidanta had got acre 8.43 decimil of land. The suit land is covered by Sabik Khata number 16 are corresponding to Hal Khata number 32 with an area of acre 2.64 decimils in the Hal settlement. In view of partition, it was previously recorded in the name of Padma Mandali and subsequently recorded in the name of Bhagyavati Mandali. It is not possible to hold that the suit property is the joint family property of the defendants and it is held that it is the exclusive property of Padma Mandali. In view of the above discussion, it is concluded that there was previous amicable partition between Padma and Golapi and the suit land fell to the share of Padma Mandali. This number 4 and 5 are answered. About the trial court completely held that it is not a joint family property and it was partition, amicable partition between the parties and accordingly it was recorded separately in their name. Therefore, Lordship may also see issue number 7 and 10, that is with regard to the will nama. Issue number 7 and 10.
What was the finding?
The ultimate, that is the finding.
What was the ultimate finding in that issue number 7?
Issue number 7.
About the will.
Will, my lord, ultimate finding.
It is believed.
Page 13, you
Page 14.
You may have disbelieved it.
My lord, the trial court believed the will.
Believed the will.
Yes, my lord. Your lordship went to page 13. My lord, towards the middle.
Since it is absolute property, so
so will is it has been validly executed. It has been proved by in the presence of also the attesting witness. So the observation is the DW3 is Nitya Ranjan Pradhan, who is an attesting witness, and he has reported that Exhibit A was prepared by Balmiki Meher as per the instruction of the.
So this
it was accepted by. So ultimate finding was as such it is felt that Padma Mandali is competent to bequeath the properties covered in the willnama in favor of Bhagyavati Mandali. These two number 7 and 10 are answered accordingly. Thereafter, the suit was allowed in favor, the counterclaim was allowed in favor of the defendants and the suit was dismissed. Appeal was preferred. I will take your lordship's attention to the findings of the appellate court. Appellate court's finding, my lord. The relevant portion I will place, not the entire finding. Your lordship may see, turn to page 25 of the appellate court judgment. Page 25. The finding starts, my lord, with 13th line, my lord. 13th line. The defendant respondent, lordship got it. The defendant respondent mainly rested upon revenue proceeding disposed of as above and the RORs. Lordship got it.
Yes, sir.
The revenue proceeding, more particularly the mutation proceedings, are quasi-judicial in nature and they do not determine or declare any right, title or interest, and those are meant for fiscal purpose only. So, in view of that, principle have been laid down that revenue entries neither create title nor extinguish any title. At best, those can be used for prima facie evidence of possession. So, in view of the matter, it is hardly acceptable from the available evidence on record that in an earlier amicable partition between the two daughters, Hara and Golapi, the dispute property application so and so. So, he disbelieved the revenue records, my lord. And so far as the willnama is concerned, the ground the London Appellate Court took is towards the bottom of your lordship will find page 26. It is nowhere mentioned, it is nowhere mentioned in the narration of the willnama that by any amicable petition among the legal heirs of Hara, the suit property, which is the land covered under the will, was failed to her share. It was not narrated in the willnama. So it was duly recorded and Pata was published in her favor, my lord, the person who executed the will. So on these findings, these are also the questions of law framed by this honorable court, my lord. And I have also, relying upon certain decisions, my lord, your lordship knows that when the presumptive value of the revenue records cannot be ignored, my lord. It has to be, rebuttal evidence is to be taken. This has been held by the Honorable Supreme Court in Civil Appeal number 1511 of 2020, relying upon several decisions of this Honorable Court.
ଆପଣ ଦେବେ ଏକାଥରେ ଦେବେ।
ଆଜ୍ଞା ମୁଁ ଦେବି written note କରିଦେବି. I am reading out the relevant portions of the judgment. My lord, paragraph 24. Paragraph 24 it speaks. Therefore, we find that the presumption of truth attached to the record of right can be rebutted only if there is a fraud in the entry or the entry was surreptitiously made or that prescribed procedure was not followed. It will not be proper to rely on the oral evidence to rebut the statutory presumption as to the credibility of oral evidence vis-a-vis documentary evidence is at much weaker level. In view thereof, we find that the High Court has erred in law in allowing the defendant's appeal relying upon oral evidence to rebut the statutory presumption of truth attached to the revenue record. This is the he has relied upon a number of decisions. Therefore, my humble submission is, my lord, since the petition, the revenue record was prepared after mutual partition between the parties, and the owner of the property validly executed a registered will in favor of the present appellant, my lord. At no stretch of imagination it can be held that it was a joint family property, and so far as the finding of the court below that the appellate authority that the revenue record has just presumptive value and it is meant for the purpose of fiscal purpose is not sustainable.
Yes.
I'll submit on behalf of Mr. Das.
Yes.
First, before I go to merits of the case or the facts, just have a look at Exhibit A, the will. Just that much. Then I'll go to facts. Exhibit A, will. नहीं
अच्छा पढ़िया कष्ट
नहीं मु रीडिंग की जाऊ नहीं शीट्स पूरा देखन पे गया 6टा सीट अछि 6 सीट्स आर देयर अपन देखन तो थंब इंप्रेशन अछि पद्मार नो सिग्नेचर ऑफ अटेस्टिंग विटनेस ऑन ऑल
टिप पद्मा मिडलिंग करो बोला
अगेन गुटे अछि फर्स्ट पेज गला तापर देखन तो नाही सिग्नेचर ऑफ द अटेस्टिंग विटनेसेस लास्ट पेज रे जा अटेस्टिंग विटनेस का सिग्नेचर अछि जस्ट लास्ट पेज को आसंत जोठी लिखिचंती बुझेइली स्क्राइब ये करचंती तापर नित्यानंद प्रधान लास्ट पेज को आसंत सो ऑल दिस 5 pages there is no signature of the attesting witness. It is a suspicious ground that regarding the execution of the will.
Yes.
Second is, in India, there is a special protection to Pardanashan women. Here the executed is, there is no evidence laid or Pardanashan, but she is a illiterate lady. So that principle applies to illiterate persons.
Yes.
Nowhere, your lordship, here what the judicial pronouncement in India is that when a deed is executed by a Pardanashan lady or an illiterate person, the duty is cast on the court, apart from defendant's plaintiff, to come to a certain finding that out of free will, this deed was executed. In the instant case, there is no finding. Upon the court finding
where is your written statement or what plea you have taken? Let us see.
In written statement pilots to the counterclaim, that plea you have taken.
Let us see that.
Sound us again.
Let's see that. Very questionable. Position बोला ये क्या?
Just put it like that. Just to balance it. Yes, my lords. What is there?
Written statement, you laid your counterclaim.
This is the written statement to the counterclaim.
Written statement to the
Because
counter.
I am the plaintiff. I filed the suit for declaration right act to interest over
Yes,
this
yes, I've got it. Written statement of plaintiff to the counterclaim.
counterclaim. That the counterclaim, that the contents of para, the counterclaim is denied. There was no partition between Padma Mendeli and Golappai Maharthur at the time whatsoever. When there was no partition, it just forceful, call it ancient partition. There was no partition. And this is a Hindu, they are not tribals. This is a case from both. They are not tribals, nor scheduled caste. They are Hindus.
Yes.
Governed by Mithakar law. That the contents of para to the counterclaim is not good admitted, and plaintiff Golapi is an innocent rustic lady having idiotic behavior, and she has not applied for any mutation to record on her contents or purpose. She also never consented to land recording knowing that consequence. The Tahsildar might have passed the order by Padma and husband Mantri. That para 5 of the counterclaim is emphatically denied, since there was no partition of suit land, other land by meets and bounds. Padma cannot be the owner of land singularly. The fraud, illegal motive behind the plea of partition claimed by defendant is evidence from her further assertion the para that subject lands were recorded in the name of plaintiff and co-sharers. The answer to Parangai counterclaim is submitted that the plaintiff has got every right, title, interest over the suit land, and the mutation producing affected assets and there be diverse the plaintiff. The arguments the counterclaim denied. It is denied Padma being issueless accepted the defendant as her foster daughter since her childhood and being satisfied pleaded the service rendered on the defendant. She has executed an arrested in favor of defendant on 12/3/2003.
No, Mr. Kuntia, you have simply referred, you have made a general, you have generally disputed that will. You have not taken this plea that she being a Pradhanashri or an illiterate lady was not aware of the documents and all. You have not taken that
Yes, my lord. Unfortunately, I argued the same thing. The reported decision of our High Court 3 decades back by Justice G.V. Patnaik. I raised the same contention, it was negative. You need not raise.
And is the duty burden is cast heavy on the person who claims benefit on the basis of on the propounder, that is there.
Yes. So, but the court also. Can I read the judgment? Chuttiya take.
Kharbuja queer.
Upon mind clear age.
Mo mind pura clear.
Like just
mo mind kichhi ambiguity nahi hai.
Hindu family joint minor. Presumption is jointness. There is no material on record. I'll place that.
Yes, please.
That applicant. There is no material on record to show they are different. Partition by meets and bounds. Even there is a record to show Hora, this is a Stridhan property of Hora. Horankar tinta jio. Jane issue marigale. Kadambi died issue. She was spinster. She died. Then 2 daughters. Plenty from mother. How je execute karchinti did 2 daughters say Harara. So natural line of succession name present plaintiff comes. Janakara dita jio. Dita jionkara gotiye child. So ye stranger court hasile. E jahanaru ule she is a stranger. Section 15 answer she becomes the inherit karchinti. So natural line of succession ko disturb kariya ko will story aschi.
It's possible. It's possible. What you are saying is possible.
My lords. After section 63 of the Succession Act will to prove kariya padibo. Kothi agya nowhere upon evidence dekhibe. These 2 witnesses ro jane examine age that Nityananda Pradhan. Kothi se kohne I was present.
Tribe was also examined.
Witnesses gotten page. Nowhere he says that I was present at the time of execution. Again, what does execute hover did? प्रत्येक पेज दस्खत होगा इन्हें सब रेस्ट रखा ना. So itself suspicious circumstance होइची yelling, illiterate. So all these grounds that just say नई modern statement.
No, yelling illiterate से कथा कुछ नहीं. सही तो पचाती है.
Out of free will. मुझसे paragraph खाली पढ़ी इधर. Just 1 minute. Second copy ଟା form ରେ
କୋଉଟା ଆପଣ ପଢିଦିଅନ୍ତୁ ଆପଣ ପଢିଦେବେ
ପଢିଲେ better ହବ ଟିକେ ପଢିଲେ ଟିକେ better ହବ
ପଢିଦିଅନ୍ତୁ
In India, Pardhan Nation ladies have been given special protection in view of the social conditions of times. They are presumed to have an imparted knowledge and word, as the Parda system are practically excluded from Shutanjot. The burden of proof shall always rest upon the person who seeks a sustain a transaction entered into Pardha Nation lady to establish that said document was executed by her, clearly understanding the nature of transaction. It should be established that it was not only her physical act, but also mental act. The burden can be discharged not only by proving that the document was explained to her that she understood, but also by other evidence, direct or circumstantial. While explaining the scope and extent of such protection, Privy Council in the case of Ganesh Chandra such and such held that the court had to ascertain a case of document executed by Pardha Nation lady, and the executant had been free agent and been duly informed what she was about. The law that applies to Pardha Nation lady equally applies to an illiterate lady, and therefore the same protection has to be afforded some test and to be applied while deciding legality of a document executed by an illiterate lady. In the aforesaid premises, even in finding of the lower appellate court that Bhargavi was not insane at the time of executing the sale date exhibit B by 2, and therefore no fraud has been committed by Matadin Agarwal in getting the sale deed, cannot be interfered with, and is not to assault by the learned counsel of the appellate. Yet Bhargavi being an illiterate lady, and there being no finding that she executed B by 2 after the document was read over, explained to her, and after knowing the contents thereof, Matadin did not derive any title under exhibit B by 2. I do not find any substance in the contention of learned counsel for respondent that such a contention not having been specially pleaded cannot be urged in second appeal. The validity of a sale deed was an issue, and the trial court found Bhargavi to be an illiterate lady, which finding has not been disturbed by the lower appellate court. The question as to whether Matadin derived it on the basis of the sale deed exhibit 2, which has been executed by Bhargavi in his favor. Bhargavi being an illiterate lady, and there being no finding that Bhargavi has executed the same after the document was read over and explained, and after she understood the contents, there is a pure question of law. In such transaction, duty being on the court to ascertain whether the party executing the document has been free agent and has been duly informed of what she was about, and the said burden of proof being always upon the person who seeks to sustain a transaction entered into an illiterate lady to establish that the said document was entered into by her, and after clearly understanding the nature of transaction, and that it was not physical act but her mental act too, and further whether burden has been discharged by the person not can always be considered by the second and appellate, same being a question of law. Here what has happened? Read over explain 9. Certificate ta dekhନ୍ତୁ se exhibit to eta ଅଛି ଆପଣ ପାଖରେ ସେଠି ଦେଖନ୍ତୁ last line ଠିକ ଠାକ ଅଛି ଆପଣ ଦେଖିବେ ଲେଖା ହେଇଛି read over explain, she must understand the contents, and after understanding it she must put her LTA, being illiterate lady. सेठी भी प्रेजेंट जो अच्छी से कहबे in front of both of us she put her LTA. We are present. No one witness examination. He doesn't say I was present. He says he put her signature, we put her LTA, I put my signature, and other person put his. So free will jo hota sound state of mind, free will, physical act, mental act, and court's duty. Here I come give emphasis on both the trial court and first appellate court. Court's duty is there. That cannot be. All right. See, coming to the partition, this is a joint family. There is no documentary evidence. Ancient partition court handle, there is nothing, and we don't know. So I'll read the appellate court order where it says the husbands and others of the family, co-personals, harass husband, husband. That is joint. That property is joint. So where can be there a partition by meets and bounds? That has been held by the appellate court that I am going to place. Your lordship may come to para 23. I'm sorry. Para. Yes.
Page 23. Yes.
Into Aramaichi page 20. Again, 3-4 page padiya. This is important. This clinches the issue.
Yes.
The defendant respondent is the stranger to the family of Hara and is putting her claim on the portion of the property of Hara Deva has come forward in the plea. There was an earlier partition with respect to the properties of her cousin mother-in-law. In the aforesaid suit, on behalf of the plaintiff appellant, one witness, P.W. Balram Karna, has been explained. This P.W. is the son of one Hari Karna, who is the recorded tenant in Khata number 68, corresponding to Hall Khata 77. As per the pleadings of the parties, Hara Deva had got a share. This fellow has categorically denied the ancestral property of Padma and Golapi were amicable partition and they were possessing the same. Before going to further, it is worth mentioning that property is an incident of evidence and Leicester has not vouched to the plea of the India Personal Law and Evidence. The question must be decided in accordance with the rules of Indian Evidence Act, though the course that amongst legal partition must be determined under the personal law of the people. The evidence of separate enjoyment is always a question of submission. Whatever principle of the Hindu joint family expresses their intention, that henceforth being the interest in joint property shall be regarded in indefinite share. There is a separateness of joint status and partition has taken place. All that is necessary is that there must be a clear unequivocal intention expressed by the members to enjoy their shares and separately. It is not further necessary there must be a separation by meets and bounds. Now in the instant case in hand, it has come from pleadings and evidence of party that disputed property was the original stood recorded in the name of Horakalno, who had also some other properties along with other co-personal in Sabik Khata number 68. There is no evidence to that what was the extent of share of Hara in Sabik Khata 68. Whether in respect of 68 a separate portion of favor of Hara was carved out. There is also no evidence. Now in the suit, defendant respondent has come up with aforesaid mentioned plea of partition between Padma and Golapi on the ground that in an amicable partition, Padma was given exclusive Sabik Khata 69 measuring 2.60 decimal, while Golapi was given the properties of Hara in Sabik Khata 68, corresponding to Hal Khata 77. From this point, she has only relied upon exhibit G and H. The orders of Tahsildar in G, the certified copy order in MC 16690 is said to have been initiated by Golapi as an apparent from this exhibit. From the order dated 2011-90 and 2691, it appears that Golapi Danta had filed an application before the Tahsildar to separate record of her name in Khata number 68 after due compromise among Harikarna and other set of Khata number. Under the proceeding, the name of Harabhayava has been struck off and in its place name of Golapi was ordered to be substituted. The said order to the Tahsildar has repeated that on the day of hearing, the other co-sharers in respect of Sabik Khata 68, namely Harikarna, Ratnakarna were absent and did not give their consent for amicable partition. This is very important, values. Case 23. And not give their consent for amicable partition of the properties gathered under that Khata. But simultaneously, the Lord Tahsildar has observed that after death of recorded tenant Harabhayava in the year 17, her legally heirs, namely Padma and Golapi, are enjoying the properties of the deceased Harabhayava. After making amicable partition of this, it is strange enough to note that the learned Tahsildar could come to know the properties Beva in both Sabik 69 and 68 under an amicable partition of the legal heirs are being processed by them accordingly, when the share of Harabhayava in Sabik Khata was not defined. Then coming to exhibit A, the certified copy of the order sheet and said to have been disposed of on the same day by Tahsildar on 26/2/91. It is found that the said proceeding was initiated by Padma, mother of the defendant.
This is also reflected, the same thing is reflected in Exhibit G. So proof of amicable partition between Golapi and Padma in respect of properties left by Hara is not further coming in above premises. The defendant respondent, upon whom the heavy burden rests for providing an earlier partition of the properties left by Hara and Padma and Golapi, she has merely relied upon mutation proceedings under Exhibit G and H and at RORs. The general principle of Hindu law is that presumption of jointness of Hindu family is rebuttable on one which can be placed by direct evidence by course of conduct. In case of old transaction with no confirmed document are maintained when most of the active participate in transaction have to be passed away. The burden still remains on the person who asserts that there was any previous partition. It is permissible to patch up the gaps in the evidence very rightly by reasonable interference from the circumstances appearing in the case. Then in a case where evidence is non-stipulated, loss of the afflux of time. Here, as already noted, part of the properties of Harawaya, the present suit property is said to have fallen to the share of Padma, exclusively with the plea that the other part of the property has fallen share of Golapi. But it is noted that the other part, which is to have been fallen to the share of Golapi, is still joined to the other co-partners. Here it is very important, other co-partners in Sabik Khata 68. So when the share of Hara is not defined in a particular khata, then how it can be possible to believe the entire property was put to amicable partition by her death or after her death? The defendant respondent has already mainly rested upon revenue proceedings disposed of above ROs. The revenue proceedings, more particularly mutation proceedings, are quasi-judicial in nature and they do not declare any right, title, interest, and thus meet for fiscal purpose only. So in view of that, principle have been laid down. The defendant neither create nor extinguishes title. The best can be used as prima facie evidence of position. So in view of the matter, it is highly acceptable from available evidence on record that an earlier amicable partition between the two daughters of Hara and Golapi and Padma, then disputed property according to Sabik 68 correspond to Hal 32.
Not necessary because he has read it.
Oh, yes. I'm sorry.
Yes.
So the first, that exhibit A, but simple manner, when a witnesses, two witnesses, they are not put in signature. That cannot be counted as treated as a will. And that because she is an illiterate lady, duty is also cast on the court to give a finding. The trial court has not done that. It held a will genuine, but these aspects have not been discussed.
All right.
No, we are not paid the
Okay, no, I'll just
again
formally keep it sparta to the next week.
Next week.
Formally, it will be there. You need not argue. You may give your note. You may
Next
give your reply on that. Entire week it will come as item number 2 maybe. Or gote achi to. Already achi. Gora missing hela. ଏତିକିରେ ବନ୍ଦ କରିଦେବା ପରେ ଅନ୍ୟମାନେ କରିବ ହେଲା 900 ଟଙ୍କା ବାକି ଦେବ 900 ଏଇଟା ଖାଲି ଦେଇଦିଅ ହେଲା heard and part list this matter in the week commencing 2nd September. Argument is over. If you can give a short reply on that day, that's all. Whenever it is taken up for the next occasion.
More stressed, more only one prayer, my love. You give stress on that signature.
No, I have taken note of whatever your
signature part. ଆଉ ଜଜମେଣ୍ଟ ଏଇ ଜଜମେଣ୍ଟ ଟା ଟିକେ ଦେଇଦେବୁ ମୁଁ ସେଥିରେ ଆଟାଚ କରିଦେବି
ମୁଁ ଟିକେ ଖାଲି ସେ ଏକ୍ଜିବିଟ୍ ଦିଟାକୁ ପଢିଦେବି ଅର୍ଡର ଅଫ ଦି ମ୍ୟୁଟେସନ ଅଥରିଟି ଏତିକି
yes
item number 41
Even the Muslim that
I don't see नहीं 2011 में let us see sir
800
no he is
wait
on 6/4/2012 four substantial questions of law have been framed by order dated 6/4/2012
oh admit he
yes
so hearing go LCR does this
LCR is there LCR is there
good right
LCR is there RSA 408 of 2011 though
408 with others
yeah LCR is there
next week
As requested by learned counsel for the appellants, list this matter in the week commencing second September. Nakabe. Second September. Khali ye rasmo. Yes.
Item 42.
42. 42 is yours.
42 is.
Eh?
42 times second September.
He's asking.
It's a week after.
It will come in the 9th September. Week commencing 9th September. As requested by learned counsel for the respondents, list this matter in the week commencing 9th September.
I will prepare a soft.
43 is also yours.
Yes. You also never see it.
The judgment of the lower appellate court is rejected by non-consideration of evidence on the form. Yes.
Respondent ki option there.
Yes, some name is there. Somebody has appeared. No, okay, nothing. Let us see. Let me just check up the. Respondent notice has been held to be sufficient because of personal service.
So that's the appellate court.
But here it is the respondent appears to be a DT.
DT, right?
DT hele to notice to service hava darkar nahi aati. DT has to be represented by somebody. You cannot proceed ex parte against the DT.
The executive officer rakha very inception it is defective because your lordship knows any proceeding relating to any endowment property. Commission has to be noticed.
Commissioner has to be noticed. So I think the state can you please find out?
Sir.
Because then it was under an executive officer. We do not know what is the nature of that. Whether it's a
filed by the respondent. Here the suit filed by the respondent.
Yes.
That was dismissed. Appeal was filed, reversed, and that is how the second appeal.
So since it is represented by the executive officer, I think let them take instruction.
Barampur endowment.
Barampur endowment. So let them take instruction because otherwise what will happen is it will result in a proceeding ex parte against the DT.
Okay.
That will not be permissible. Without notice. Notice is sufficient. They have not appeared. So that is why I am asking you to use your offices to find out whether. It appears that notice of the appeal was duly served on the respondent, but there has been no appearance so far. It is further seen that the sole respondent is a DT being represented by the executive officer. In such view of the matter, the State Council is requested to ascertain whether the respondent can appear through the executive officer. That's all. List this matter.
Would a copy be there?
Let an extra copy of the appeal memo be served upon the State Council. List this matter.
21st October.
September 30th September. In the week commencing 30th September. I would not like to proceed ex parte against a DT. 30th September. Week commencing. You obtain instruction?
Sure. If you the interim order achi, if your lordship looks at order dated what? The date will be 3/1/2023.
What is that interim order?
This case 14 of 2013.
3/1/2013.
14/1/4.
Yeah, there shall be status quo as on date. That will continue. Interim order to continue.
Item 44. Status quo to continue.
Yes.
Good.
Item 44 on behalf of Mr. Dayananda Mahapatra will be taken up 2 weeks after. I am for the respondent number 1 and 2.
It's a 2014 matter.
Mr. Mahapatra suffered some illness, suffering from.
Oh, you are suffering from dengue. Yes, yes. Therefore, adjournment is made on behalf of Sri Dayananda Mahapatra on the ground of his illness. List this matter in the week commencing. These are paper. Okay. in the week commencing 23rd September.
Deeply okay.
Item 45.
Pass over.
Item 46.
Pass over for the day. Yes.
Item 47.
May I please, your lordship? Let the present respondent as plaintiff my lord filed a suit before the Learned Civil Judge Junior Division Bhavani Patna for injunction against Bhavani Patna municipality.
You are the plaintiff.
No, I was the defendant.
You were the defendant.
Bhavani Patna municipality was the defendant. And the prayer in the suit was.
You are Bhavani Patna municipality.
My lord. Bhavani Patna municipality is the appellant before your lordship.
No, that's all. That's all. So you were the defendant there.
Defendant in the original.
Yes.
In the suit, my lord. And to declare that the municipality doesn't have any right title interest over the suit land, and there is a house, my lord, suit house, and the defendant municipality should be restrained to collect rents, etc., and cannot interfere in the possession of the plaintiff. This was the prayer, my lord. And the contention was that, my lord, that the land, suit land originally belonged to the ex-ruler of the Kalahandi. In the year 1964-65, it was recorded in the name of the state of Odisha under Exhibit 1, my lord. Before that, the son of the ex-ruler had executed a deed of assignment with the municipality in the suit house since 1951, continued to possess, and he resided there. And after his death, he continued to possess the suit house. And accordingly, he has perfected his title on the basis of adverse position. And on the contrary, my lord, our pleadings were that the suit is not maintainable because the state of Odisha has not been added as a party, and he has also prayed for declaration. And second, my lord, there was an earlier suit between the father of the plaintiff and Bhavani Patna municipality. That suit was filed by Bhavani Patna municipality, Learned Civil Judge Senior Division, my lord. And this suit has been filed before the Learned Civil Judge Junior Division Bhavani Patna. And a prayer has been made to declare that the decree in that suit is not binding on the plaintiff. So our contention was that a higher forum which is files a decree, a lower court cannot, my lord, declare that the decree is not binding on the plaintiff. Therefore, on that score also, the suit is not maintainable. And the decree passed in that suit, my lord, attained finality because the father of the plaintiff, nor the plaintiff, at any point of time challenged that decree, my lord. And as such, decree of recovery of possession was granted in favor of the Palangir municipality. So it was our humble submission that the suit is hit by the law of res judicata because it was decided between the father of the plaintiff, and after it, it is binding on the plaintiff also, and it is heard by the list of res judicata. While admitting this present appeal, my lord, the suit was dismissed, my lord. The suit of the plaintiff was dismissed. And the Learned Trial Court held that it is, I cannot declare that the decree is not binding because Learned Civil Judge Senior Division passed the decree. The state is a necessary party because under Exhibit 1, which is exhibited by the plaintiff itself, the state is the true owner and he is a necessary party while deciding the title. And all scores, my lord, the case of the plaintiff fails and therefore dismiss the suit. Thereafter, my lord, the plaintiff carried an appeal. The appeal was allowed, my lord, by the Learned District Judge on the ground that the municipality doesn't have a better title than the plaintiff. And the decree passed by the Learned Civil Judge Senior Division is not binding on the plaintiff, not hit by the law of res judicata, and there is cause of action to file the suit, and accordingly he decreed the suit and allowed the appeal. Challenging the judgment and decree passed by the Learned First Appellate Court, Bhavani Patna municipality approached your lordship in the present appeal, my lord. While admitting the appeal, my lord, a coordinated bench of this court, my lord, has been pleased to formulate the substantial question on 9/1/2019, B and C, my lord, whether the Learned First Appellate Court has committed grave error in law in giving a finding that the plaintiff has better right and title over the suit house than that of the defendant, when he has not disputed the finality of the judgment and decree passed by the Learned Civil Judge Senior Division.
Let us straight away go to that part of the judgment of the First Appellate Court, where he holds that the plaintiff has a better title.
Let
us go to that.
And another substantial question is that whether the
state is a party. I've seen that.
Your Worship, may kindly come to. Page 10 of the London First Appellate Court's judgment, my lord. Internal page. Last line, my lord. Accordingly, it is held. My lord. In absence of any material showing transfer of the suit house by the true owner state of Odisha in favor of the municipality.
Read it from the top.
My lord. The fact remains that Bhavanipantam municipality doesn't become the owner of the suit house. To add this, after 1964-65 settlement, the suit house became the property of the government and recorded in the name of general public Sarva Sadharana. There is nothing to show either that after preparation of the record of rights in the 1964-65 settlement, the government entrusted the suit house in charge of the municipality to maintain and to manage. In section 121 of the Orissa Municipal Act 1950, at clause F, it has been provided that all buildings transferred to the municipality by the state government or acquired by gift, purchase or otherwise for local public purposes become property of the municipality. In this case, there is no such evidence of transfer of the suit house by the state government in favor of the municipality for local public purposes. In the earlier suit, that is TS number 4 of 1973, the court has held the father of the plaintiff, namely Hemanta, to be in possession of the suit house on ground at least since 1/2/1962, if not since 1951, as per claim of the plaintiff. And despite decree for his eviction therefrom, the same has neither been executed nor the defendant therein himself vacated the same. Similarly, the present plaintiff has never been ousted from the possession of the suit house until now is continuing its possession. So, in view of such factual position relating to possession of the suit house and in absence of any material showing transfer of the suit house by the true owner, state of Odisha, in favor of the municipality, it cannot be said that municipality has a better title than of the present plaintiff, Jayant, over the suit house. In such situation, the plaintiff has every right to protect his position over the suit house until evicted in due process of law by the true owner. My above view is countenanced by the decision of the Honorable High Court in case of Ratan Garal versus Hiralal Ram, dead after him is LRs.
Now, this, Mr. Kanta, this takes me to the question: if the earlier, in the earlier suit, which was decreed in your favor,
my lord,
you never executed that decree.
My lord, we issued notice to vacate them. He challenged that notice in a writ application, my lord. And status quo order was passed by the Honorable High Court.
Then
thereafter, my lord, he continued. We also went on issuing notice, but the fact remains that, my lord,
what ultimately happened in the writ application?
That has not been exhibited in the suit or appeal or nothing, my lord.
So what is
as such, my lord, that has been disposed of to my instruction, but I do not know the number.
It has been tagged, your lord.
Tagged for reference, my lord.
No, that's true. So let us see what was the order, what was the final order passed there.
And it has also been mentioned, my lord, by the Plan and Trial Court.
OGC number कितने दे देंगे?
No, that was disposed of by directing you to proceed with directing the petitioner of that writ application to proceed with the representation that he has filed with the Tahsildar.
Yes, before the Tahsildar.
So what happened to that?
That is pending before the Tahsildar. That is under OGLC Act, lordship. He is the appropriate. He is the owner. State is the owner. Honorable Court did not want to interfere with this matter.
No. State may have been the owner. I will ask you that question when your turn comes.
Sure.
State may have been the owner, but fact remains that there is a decree of a court directing eviction of the plaintiff.
And that decree has not yet been executed.
So, does that clothe the plaintiff with any further right when that particular decree has not been satisfied? So you prepare your...
I will submit.
Yes.
However, declaration of title can also be decided in absence of the true owner, my lord. Had it been a simply suit of permanent injunction or injunction, the matter would have been different.
Fact remains that the earlier decree still subsists. It has not been
challenged by, and it is the admission of the plaintiff that it has not been challenged either by my father or by myself. And that has also been mentioned by the Land and Trial Court. He has stated that I could come to know it in the year 1980. After 23 years also, I did not challenge it and filed the suit in the year 2011. He has also deposed, and these are the facts on record also, my lord. And thereafter, my lord, the Land and Appellate Court has also committed a grave error of law, page 12, my lord, your lordship may kindly see paragraph 12 of the finding of the Land and First Appellate Court.
Paragraph?
Paragraph 12 of internal page 12. Regarding operation of the principle of res judicata, my lord, got it? I am of the considered opinion that in the earlier suit TS number 4 of 1973, the status of the parties were different, whereas the status of the parties to the present suit are different. To add to this, the basis of claim of the present plaintiff in the suit being somewhat independent than basis of claim of his father in earlier suit, the finding in the earlier suit TS number 4 of 1973 cannot operate as res judicata to the present suit.
All right. We'll continue later. Huh? What is your initial response?
Initial response to this, your lordship, the simple thing is this is not a dispute regarding title. The simple and humble prayer of the respondent is, I am the possessor, I am having better title over the suit land than the
No, on what basis are you claiming better title? Only
I have been continuously possessing till date. I have never been ousted. And what the earlier 1974 decree, that is by the limitation within 12 years that has to be executed.
No, I'm putting a question to you so that you will be able to better appreciate better assess the court on the next occasion. You see, it's a question of your antecedent title. Your father was in possession.
Right.
Initially, you have claimed possession through stepping into the shoes of your father.
Right.
All right. Now, as insofar as your father is concerned, there was a suit. The suit was decreed. That decree still subsists. Keeping this in mind, you make your submissions. We'll continue. All right. Third in part. Does this matter in the week commencing? 9th September.
Your lordship, my lord, your lordship may say from 17th September, my lord.
All right, 17th September.
September.
I can complete it, but because of other judgments have to be pronounced, so can I phone call the hogi?
Or next week, my lord.
No, 17th September. 9th September, I'm ready.
But grandmother death anniversary is to Bangiri GV बोलेगी कैसे थी prayer.
17th September.
17th.
Yes.
Item 48, my lord, on behalf of FP Boss, my lord, pray for next week.
Next week is prayed for.
Interim order is continue.
Interim order to continue.
49.
49. Yes.
Last occasion, lordship had admitted the appeal, my lord.
Today, lordship may call it tomorrow.
All right. Pass over.
Then so right on 5.
Tomorrow. Yeah. Pass over.
So right on 7.
Same.
Item number 7 for the respondent, my lord.
It is being passed over. It will be again called out tomorrow.
So right on 16.
16. Mr. Sonagi was here.
He was here.
ठीक पढ़ लो बोलूँ तो पासो
So right now 17.
17, my lord, on behalf of Jyoti Ranjan Deo, my lord, password for the day.
All right, password for the day.
So right now 18.
18, yes.
The appeal was admitted.
Where is Mr. Ghosh? Yes.
So it was admitted on 30th 7. LCR has been called. So I have filed a miss case, IA 440 of 24.
440.
Because I have filed that in that application, they have filed a mutation proceeding. I have prayed for stay on that proceeding till disposal of the second appeal. So once it has been admitted, it will be disposed of.
I have nothing to say, but I have intimated my client to come to that. Therefore, it would be injustice. It has been posted to 30th of September, noted down in that noting. So, client would come before that date and file objection. So, let it come on. That apart also, if my learned friend is serious about the matter, let it be heard finally. I'm not FCRA
already fixed to 30th September.
No, it will be heard.
I'm willing to concede that, you see, this is a 2023 matter. The court is not very, keen to take up these matters when there are 2003 matters pending. But nevertheless, I'm willing to take up this matter. You file an objection. Till such time, let it be stayed. What is there? And on that day, when you file your objection, and in the meantime, I will remind the court below to send the LCR so that the matter can be filed in this court.
It is already called for.
Actually, it will be reminded.
Miller, sorry. Miller, what I submit, my client would misunderstand me first. Second, 30th September, his main case is right to repurchase. I am the plaintiff, filed the suit. I am the purchaser, plaintiff from one of their brothers. Miller, that my suit for partition is decreed by the learned lower appellate court. His only claim is right to repurchase, which is denied rightly and justly because his father, he is for the contesting defendant number 1. Contesting defendant number 1's father, Vidyadhara, had filed a suit by
That's all right, but the second appeal has been admitted. Yes. Now, if what will be the effect of the mutation? Mutation is to give effect to the mutation order is to give effect to the order passed by the first appellate court, isn't it?
It a fiscal document, tax does not clothe any right title interest in favor of any party. Mutation.
Presumption argued. So I will state, I will grant you time to file objection. Till such time, I will just direct that he will not proceed. No, he will not pass any final order till the next date. That's all. That is all I will say. I will not state. IA 440 of 2024. This is an application to stay the mutation case. Number 124.
May I suggest, would your lordship please be agreeable to find that it would be subject to the result of the
unnecessary complications. You are one 24 of 2024 pending. The PK Ghosh and counsel for the respondent seeks time to file objections. The counsel for the petitioner, for the appellant petitioner, submits that the appeal being otherwise ready can be disposed of. And if in the meantime the mutation case is finalized, it would lead to unnecessary complications. Considering the submissions as above, it is directed that the mutation case may proceed. No order shall be passed till the next date. Stop. It is open to the respondent to file objection to the IA. List this matter. What a short date, Kora.
In the 23rd September.
In the week commencing 23rd September, remind the court below to transmit the LCR without any further delay.
Okay.
Yes, Mr. Sorry, wherever your matter is called, you are going.
Bail go to late in this case, item 16 matter.
Item 16, yes. What do you want?
Say, without serving.
And A to 1E. Why have they not given the postal tracking report? When was notice issued? Notice the issue, na? Let it come. You tag the postal tracking report, we'll see, we'll find out. Postal tracking report, asu say through na. List this matter next week along with the postal tracking report. From there, 9th September. In the week 9 September. If it is found that the notice is sufficient, no further notice will be required. So let the postal tracking report. Yes.
So item note 23.
23 is for admission. Yes.
On behalf of Mr. Barik, please next week.
So 2003 matter, no.
So only Friday.
Hearing order on Friday, all right, pass over for the day. Be prepared, be prepared, be prepared. 2003 matter, yes.
So item number 26.
36, yes.
Lordship for the appellants. Lordship, this is a reversing judgment, but the trial court has.
Who are you?
Lordship for the appellants.
No, when the court asks you who are you means what is your status?
Plaintiff, Your Lordship.
You are the plaintiff.
Yes, Your Lordship.
Suit for?
So for declaration of right title of an interest.
Additional yes. What are the facts?
Your Lordship, the brief facts that the plaintiff has purchased an area of 0.22 acres, Your Lordship. And the defendants have also purchased from the same land from the same vendor, Your Lordship, for 0.01 decimals. Both of them constructed a thatched house, Your Lordship, and then plaintiff lent out the thatched house to the defendant as he was a karigar and he was using that house to make idols, Your Lordship. After some years, the thatched house got destroyed. The defendant requested the plaintiff to exonerate him from paying rent. He was exonerated, he was not paying the rent. After some years, the defendant completely changed the structure of the thatched house and started constructing a pakka house encroaching upon the plaintiff's land, Your Lordship. When the plaintiff approached defendant with a private ominer to measure the land, like the amount of land, the defendant avoided it. He didn't let out the measure the land, Your Lordship. In the trial courts, it was decreed that the defendant has encroached over the property of the plaintiff's land. The lower appellate court reversed the decree, Your Lordship.
Let us see.
Page number 8, Your Lordship.
Yes.
Further from the record, it appears the plaintiff through claims that the suit land is his land, but in spite of his admission that he got the RMS ROR without any explanation, suppressed the copy of the said ROR, which has been published in his name to.
Any idea what is RMS ROR? In Balasore, they use MS ROR. Yes.
This is the Raghupati major settlement records.
No, they use it as an MS. They were never using it RMS.
RMS I have not heard.
No, for the first time I'm seeing. I have started my career at Balasore. I was the additional district judge there, so I know they use only MS, CS, and then previous that settlement is known as prior to CS, the current settlement or the cadastral survey, whatever. Probably I would do a settlement. Balasore being that area, so RMS, I'm hearing it for the first time. Any idea? No, you just now said Raghupati settlement.
There it is.
Raghupati major settlement.
Raghupati major settlement.
Yes. Anyway, so what happened? On admission that he got the RMS without any explanation, suppressed the copy of the ROR.
Had the plaintiff filed the copy of the RMS ROR, which has been issued in his favor, and filed contemporaneous document including the index to correlate the suit land, and the same is in possession of the defendant, then the matter would have been different. Since an area measuring acre 0.22 decimal in the name of the defendant, the plaintiff, in absence of any proof, cannot say that the suit land has been either included in the ROR of the defendant or the defendant is in illegal unauthorized occupation of the same. So the ROR doesn't create the right nor extinguishes the right. The appellate court constructed a moot issue, well, Your Lordship. Page number 5. Whether the defendant was the tenant under the plaintiff over the suit land, and if yes, then the defendant is required to be evicted or not. The cause of action did not arise when he was a tenant. The action arose when he denied to measure the land when the plaintiff approached him with a private ominer. The question of defendant being the tenant or not was not considered in the trial court, Your Lordship. Secondly, they reversed the judgment, page number 6, Your Lordship.
Yes. I'll admit it on only on A. Come to your substantial question.
Lordship, A.
Come to your substantial question of law where you have framed in
Yes,
your
sir.
say, appeal memo.
Lordship, on the admission, the substantial question of law B and C was taken up. Ground 5, B and C. Whether the learned lawyer appellate court below is justified in ignoring the report of a private omino for want of notice to the parties before measuring.
But this has not been admitted as yet.
Admitted, Your Lordship.
When was it admitted? No, B and C, right. 16/5/2016. So this is for hearing. Notice, I thought this is for hearing under Order 41. Order 41
It has come under Order 41.
Oh, I'm a little bit confused. So anybody appear?
For respondent, yesterday there was somebody for respondent.
So then we'll pass it over. Pass it over, we'll call it out again tomorrow. Maheshwar Mati. Okay, we'll call it out tomorrow again. Yes.
So right now 32.
What is so amusing about it?
He was there yesterday and he opposed it also. So
Opposed what?
like it was Passover. He said there is a status quo, so that's why he.
We'll call it out tomorrow. Didin aur achi list sorry didin achi. So anybody who appears.
You should interim order to continue.
No, I'm not arguing it.
I apologize.
Yes. Then.
So item 32.
That IAH COB, my lord. Yesterday the matter was before the lordships, my lord. Ex parte judgment was passed.
What has come? You said IA.
IA, my lord.
Kaun IA? You filed any IA?
Yes, my lord.
Stay of further proceedings in EP. This has not been admitted as yet.
No, my lord, not admitted.
Not admitted. Okay. We'll admit it. Kaun hai is dekhe? Matter ta kaun?
My lord, ex parte judgment was passed, my lord. Against the defendants, my lord. The present.
Oh, that was
yes, my lord. Yes,
so on the ground of limitation.
My lord, on the ground of limitation of 88 days.
I'm still doubtful whether against the rejection of this petition for condonation of delay, whether a second appeal will lie or not. Will it lie?
If a refusal to condone the delay,
that will amount to. So what substantial question of law can be framed?
That the grounds taken in the condolence.
Whether it constitutes sufficient cause or not.
Yes.
All right. I will do one thing. I will issue notice on the question of admission.
Right.
All right. Issue notice to the respondents on the question of admission by speed post, fixing a short returnable date. Requisites be filed by tomorrow.
Right.
So within 3 working days. 3 working days. List this matter. Okay. October.
Commencing 21st October.
In the week commencing 21st October. IA 9/37 of 2024. Yeah. Further proceedings in EP number 6 of 2023. Pending in the court of Kuri. Court of Senior Civil Judge Rajagangpur, arising out of CS number 109 of 2018, shall remain stay till the next.
Okay.
Sarla. I'll get that. I can take it.
So item number 39.
ठीक है चलो
item number 45.
And for the appellant, my lord, they filed an IA for additional evidence that has not come on record. IA number 1006 of 24.
100.
106 of 2020.
Yes, pass over it. Yes, then
item 46.
46. This is for hearing. Yes, you are there.
Not only intervention, Lordship, item number 5. 2 IAs.
Item 46.
No, Lordship. 46 pass over.
Pass over. Then
Item 5.
item 5 is sorry.
Pass over. IA file is delay content or substitution.
Item 5.
Again.
Item 5 is 2017 matter.
Again,
All that is for substitution. Yes.
substitution and delay.
All right, we'll do it. We'll do it. Yes. IA. Which is who has died?
Your Worship, respondent, the sole respondent.
Sole respondent has died. Which is the IA for condonation of delay? IA?
IA 91 of 2020.
Where is your file? Where is your brief? Why are you not holding the brief?
Your Worship,
Why are you not holding the brief? You are a young counsel. You should always hold the brief. That is your power.
I apologize.
Then?
Your Worship, IA number 91 of 2024 is for.
So we'll issue notice. All right. IA 90 or 91, right? Issue notice to the PLRs of deceased respondent, of the deceased sole respondent by registered post with AD, returnable within 4 weeks. Requisites be filed within 3 working days. Is this matter?
Commencing 21st of October.
In the week commencing 21st October. Sala?